Services and Public Administration. At this meeting, the committee will convene its second public hearing with officials on the inquiry into the state of contract employment in Trinidad and Tobago. You can also view a live stream of this meeting on our YouTube channel, ParlView. For more information, visit our website at www.ttparliament.org and follow us on Facebook, YouTube, Twitter, and Instagram.
The Vice President.
Senator Creese.
Yes, Mr. Vice President. The whole question of jurisprudence and new perspectives on it, I think should be engaging our attention, not only with relation to the issue of fines, but also the time frames, because one of the problems we keep having is the inordinate length of time matters take within the judicial system. So although I've heard allusions to the fact that on the question of the tribunal, that people have recourse to the high courts and the appeal court and so on, and even all the way to the Privy Council, apart from being costly, it is time-consuming, and therefore any activity, and we're talking here about land, and possibly for some citizens, the sale of these lands. So therefore, if they have to go through all these processes, the question of other people being able to obtain mortgages and so on, and getting necessary tax clearances to, convince the mortgage lender that they should underwrite a particular mortgage. There are implications for that process, so that apart from the time allowed, and we start off with allowing the commissioner a year in which to handle the complaint, I feel we should also circumscribe the tribunal with a time frame as well, so as to guarantee the citizen that he will not be unable to do business with his property, to dispose of it, to discharge of it in any fashion, because he is constrained by, I think the lawyers call it lis pendens, a matter pending, with regard to his property. But on the broader issue of the tribunal itself, one of the concerns that I have with regard to that is the criteria. I think the legislation is not sufficiently discerning or discriminatory in terms of what are the stated qualifications for membership on the Valuation Tribunal. I recognize, I won't repeat the points made by Senator Brian Bigg on the question of the lawyer on the panel and what is his particular, sets of experiences. For me, I would have wanted that section to start off by insisting, of course, that the member of the tribunal should be a citizen. I see no reference to that here as a citizenship status. And I think that the first qualification should be that you are a citizen of the country. And then the question as to whether or not you have any kind of criminal history, that is, that there should be no prior convictions. Good? I see as being a relevant qualification. And if we are saying that bankruptcy should be a disqualifier, then it should also lack, it should also be in the list of qualifications. There should be no bankruptcy matters pending or in your past if you are to, qualify for membership of this tribunal. Matter of fact, I think it should be plainly stated that you should not have been guilty of an offense involving dishonesty if you are to qualify for membership on the tribunal. So there's need to really take time out and review what are the particular qualities we would like to see in members of the tribunal. And of course, I support the perspective that the time frame, the term of office, the tenure, should be 5 years and not 3. Good? Again, given the time span for legal matters, given all the issues that are involved in land registration matters, and the time frame for those of us who had to visit the Registrar General Office with regard to registration of deeds and transferring of titles and so on. 3 years is no time at all. So that in preliminary activities with regard to any tribunal matter, 3 years would fly. So before the person even gets accustomed, has handled 1 or 2 matters, he's on his way out. And we know we have a problem in Trinidad and Tobago with the handing down of judgments on a timely basis. So are we setting people up to start a matter that they cannot finish? So it has to be nothing less than 5 years. 3 years really doesn't fit into the time frame that we have been functioning in, and this is not the place to experiment with time frames. And then the whole question of removal of members, I'm of the view, although I know in many instances where the law or the regulation says minister, it is in fact the cabinet. And when we speak of cabinet, we all know that nothing occurs in our cabinet without the clear approval, consent of the Prime Minister. But I feel, because it's a tribunal, the Prime Minister should be the one to trigger any removal, for cause, should be triggered by the Prime Minister and not the Minister himself. So the talk of the Minister may suspend a member of the tribunal, I don't think that's the way to go. Just looking at it on the paper, I have a problem with how that sounds. So that it should be the President appointing, and the Prime Minister as the head of cabinet and the executive being the one to trigger the review of the validity of any, the continued membership of any member of the tribunal. And of course, well, I agree with the provision that bankruptcy will be a ground for removal or subsequent conviction for any offense involving dishonesty. Again, to return to the question of fines, I would want to draw your attention, Mr. Vice President, to Section 25, and that would be 25H. And I'm looking at B and C, the whole question of what would happen or what should happen if there's a failure on the behalf of any citizen, any person, or any body corporate to comply with the request for documentation, the subpoenaing of documents by the tribunal. I think the power of institution and the response, given the culture in which we operate, to the tribunal would have to relate to the power the tribunal is perceived to have. We have a culture here where people tend to obey the laws when the police are on the beat. And if we recognize that, then there's no point setting up a tribunal if we do not give them the mechanisms to police the powers that they're supposed to reside in them. So I think we should copy from, I think it's used to be the Town and Country Planning Act, where failure to comply with a request to stop or discontinue any construction had a daily fine, the automatic imposition of a daily fine. I think that this is relevant here. And in keeping with the perspective I have on a new jurisprudence where fines relate to your financial worth or your financial earnings or the value of your property as the basis for fining, so that when we fine you, it must hurt. The same way for, as they say, the common man, quote unquote, and the more affluent person. So therefore, I would want to feel that in default of supplying the documents requested by the tribunal, there should be $100 a day fine for individuals, whether and this fine to be whether they are the sole owner or they own a property in common. Everyone there who fails to participate in the request for documentation would face a $100 a day fine until they provide the documentation. And similarly, for corporate entities, $1,000 a day as the fine until they cooperate with the tribunal. I am suggesting this because it is the only language which many of us speak, other than English, the language of fines and punishment. And therefore, if the tribunal is to be effective, then it has to have that kind of clout. So that in closing, Mr. Vice President, I want to reiterate that I have three concerns with this bill. The first is that it should have a different fee and fine structure so that it would be meaningful and effective, that the tribunal which is the justice instrument within this bill, should be appointed by the president, should have as their basic qualifications, apart from the professional qualification, and I support Senator Beg in that even as a lawyer, it should indicate which aspect of the law their 10 years of experience should in the main relate to. That, of course, they be appointed by the president and removed by the president, and that I would add to the qualifications the whole question of not being bankrupt, of not being convicted of an offense, especially offenses related to honesty. And that the fines for failing to respond to the tribunal should relate on the individual basis, $100 a day until they free themselves of the contempt for the tribunal, and for corporate entities, $1,000 a day until, they're devoid of contempt for the tribunal. And finally, that there should be time structures, because without time structures, yes, there's a provision here for a one-year response by the commissioner, but the tribunal should also be mandated to deliver within a specified time frame. And I am suggesting that their time frame be 1 year, because we are looking that if they use up most of that year, it would have been 2 years, the year they spent at the commissioner's office and then a year spent at the tribunal. That's a long time to have somebody's business enterprise, their financial possibilities tied up, because we're talking about land, and we're talking about if you are going to be able to dispose of your land or to do any major transactions with it, the mortgage and financial institutions will require that you provide some kind of tax clearance certificate, which will not be available if you have a tribunal matter pending. I thank you, Vice President.
Senator Richards.
Thank you, Mr. Vice President, for the opportunity to contribute to this bill, the Valuation of Land Amendment Bill 2018. I know I've promised in the past that I will be short, and I will be seated by 5:30. By 6 o'clock, sorry, by 6 o'clock. Let me start by saying I just have 3 concerns. The fortunate thing is that so many have spoken before that I don't want to be running afoul of the standing order related to tedious repetition. But just 3 main points and a general principle in terms of the issue of land valuation, which really is the foundation of the bill, which I'm presuming in the government's perspective will be debated on Friday, which is the property tax, and they, to me, inextricably linked when you think about it, and you can't do one without the other. So really and truly, in my perspective, they should have been debated together, but that's all academic now. On principle, and just referencing Minister Hunt's contribution or part of it, where he indicated that, this is part of the government's obvious revenue generation in terms of tax collection. And it's been in abeyance for a number of years, heading toward 10 years, which really puts it in the category of an unaccounted for subsidy to the population, when you think about it, because it's money that should have been going into the national coffers, which have not been going. But then, in principle, when you think of valuation and property tax, and I try to stay away as much as possible from property tax, citizens should contribute their fair share. So the valuations have to be done. We have to go through a transparent process to get that done. And then properties are taxed so the government can get the tax. But what are citizens getting for that? Minister Hunt spoke about sharing the burden of the times that we're in. But if you are paying your fair due in terms of any taxes, I think there should be certain expectations on behalf of the population. because the government has put certain measures in place to ensure that people comply and to ensure that taxes are collected. But does that mean that citizens who are going to be compliant, or who will be forced to be compliant in some cases, are going to get the benefits for it, including proper roads, drainage, recreational facilities, disaster response mechanisms, effective ones at that, and protection from undesirable aspects of living in some of these areas? You know, and I'm not sure that's always the case in these scenarios. And we need to look at that. We need to look at, are people getting what they should from the state when they are compliant? And they should be compliant. Part of what we need to do is make sure we have the mechanisms and the resources in place where this particular bill and the mechanisms contained therein are in place to make sure that we can actually do what the bill is intended to do. One of the and I said there will be just 3 short clauses that I want to reference. And that, the first one has to do with Clause 5 of the bill, which will amend Section 6 of the Valuation Land Act, Chapter 58(3), or 3, to increase the penalty of the failure of the owner of the land to file a return of the land from $500 to $5,000. And I agree with several speakers before. Minister LaHunt spoke about the fact that we don't want it to be a light amount because it needs to encourage people to be compliant. But laws need to be applied to have equal effect across the society. And somebody, as Senator Creese indicated, who has a $14 million house, who has an income in excess of X million dollars a year, that's pocket change for them. So that is not going to be as a strong incentive as somebody who has a much more moderate income. So I think that needs to be looked at in the context of it possibly being tied to income level or property value, so that it has the desired effect, and the desired effect is obviously to ensure that people file their returns on time. So that if you think of the $5,000 fine on one instance for one part of the socioeconomic group compared to the other, it's really not an equal distribution, and laws need to be applied or seem to be applied equally. And when you think of land and valuation of land, it goes back, it's really one of the fundamental rights enshrined in our Constitution, where you knew at one point, in terms of the landed gentry issue, where land, the value of land cannot be underscored, or understated, I should say. Enough land meant rights to vote, legacy for families, security, and the opportunity to move ahead in society. So these provisions need to at least seem to be applied equitably across different sectors of society. So I'm hoping Minister West can address that in her wrap-up in terms of possible caveats or amendments to that particular clause. The other part of it that I'd like to address is Clause 6, which inserts a new clause, a new section 7A, which would require the Commissioner, where he is of the view that more than 50% of all lands in Trinidad and Tobago have been valued, and that valuations should take effect, to notify the Minister, who would, by order, then declare the valuations are in effect. And given my experience in this country, it may seem very palatable and doable on paper, but getting to the point of 50% compliance may not be as easy as we think it is, given the resources. I remember a couple of months ago, the Honourable Minister of Planning and Development answered a question graciously, and she spoke about challenges in local government in just getting people to stick to the rules and to getting local government agencies to have the resources to value properties, so that that aspect of it can be completed after this hopefully is done. So I don't see that that is as easy as it seems on the face of it. And if we're thinking of the number of years this has already been in abeyance, to get to the point where more than 50% of the lands in Trinidad and Tobago have been valued or filed, it's going to be a challenge of sorts. We have to do it. But what are the mechanisms to ensure that's done in the shortest possible time, so that government can indeed start collecting property tax after these properties are valued? And that, to me, we need to look at in terms of resources and mechanisms by which that intent can be actually operationalized. The other aspect of it is what many others have referenced before, and that's the tribunal. And in principle, I think the tribunal is a great idea in terms of the evolution of this situation. But again, I don't see the aspect of having Her Excellency appoint the tribunal, or at least the chairman, going in contravention to the intent of the tribunal. And very often, societies look at situations like this where it seems that more and more power is being reposed in the hands of the executive, and we're taking out more checks and balances. And one of the questions I think the government needs to contemplate, and this is not casting aspersions as to the opposition or the present government, but would you want that situation if you were in opposition? Would you be comfortable with that situation? Because we can't make laws for now, or who we know is in power, or who we have confidence in, but we need to make laws that protect the society, no matter who's in power. And I don't think that putting an amendment that Her Excellency is reposed with the power or the responsibility to appoint a chairperson of the tribunal is going to nullify the effect of the amendments in the bill or the bill itself, or put any roadblock in the government's way whatsoever moving forward. I think we've all echoed praises to the credibility and competence of Her Excellency, and generally we have that confidence in our head of state, so I don't see why that would be anathema to the intention of the bill in terms of where the government wants to go with this. You know, and I got a nice quote that I think can lend some credence here by Reinhard Niebuhr, which says, and I quote, "Man's capacity for justice makes democracy possible, but man's inclinations to injustice makes democracy necessary." And we need to make sure that the population feels that we are using all the instruments of state possible to ensure that there seems to be checks and balances in place at every step. So I'm hoping that Minister West and the government considers that also in terms of possible amendments when we reach committee stage, which I don't think, as I said before, is going to be anathema to the intention as espoused by Minister West in her piloting the amendments. One of the other points that I want to quickly mention is the issue that my colleague, Senator Shriki Soon, mentioned, which is in terms of the disclosure, the level of detail of disclosure of the forms, which, if you understand rentals and property values in Trinidad and Tobago, change so quickly. People can rent something now, and they may file it today, and it's accurate as they know it. And so many circumstances on that form can change by the time it is checked and vetted by the tribunal, if that comes into play. That would make the person liable for inaccuracies on that. So, well, willingly, yes, I understand that, Minister Langhunt. But, you know, I'm not a legally trained mind, but willingly suggests some sort of intent, and I don't think intent is that easy to prove in law. So how are you going to say, well, they willingly misled you? You know, and finally, because I promised to end at 6 o'clock, you know, the option that the AG mentioned in terms of, yes, the going with queries to the court, the High Court, the Appellate Court, and then possibly the Privy Council, is a great option. But one, many people spoke about the cost involved. And if you think about the situation in our courts presently, and we have, according to your suggestions, Minister West, through you, Mr. Vice President, 700,000 outstanding valuations. If we take 10% of that and say, well, they're queries, that's 70,000. If you take 5% of that, that's 35,000. Can the courts cope with that onslaught in a timely manner? We're just adding more burden to the court system. So I don't know that that is going to be a feasible way going forward in terms of the consideration with that. I mean, it's admirable that people have that option. But, you know, we probably need to put some sort of other caveat in place so we can expedite that situation so that we don't end up just adding another layer of bureaucracy and problems into already overburdened and in some people's estimations, failing judicial system, where we want to expedite these matters these situations to the benefit of the state in general. I would have liked also, in closing, to see this kind of bill done in the context of a comprehensive land use policy in Trinidad and Tobago. Because if we had a sense of what we plan to do with lands X and Y and the developmental plan regarding those lands, people would have had an idea of, well, my property would be worth X and Y because development A and B is coming up, and that will also bode well for the real revenue generators moving forward when the property tax is debated, which is the commercial and industrial plants where, to me, the bulk of the money is going to come. So if we had a comprehensive land use policy and development plan, and yes, there's some indication in government's 2030 vision, but it's not as comprehensive as it should be in terms of a land use policy. So with those few words, Mr. Vice President, I'm 10 seconds shy of completing my first confirmation of being short, and I thank you for the opportunity to contribute.
Senator Obika.
Thank you, Mr. Vice President. As it is my distinct pleasure to accept the privilege to contribute to this very important bill in the timeline of our history in Trinidad and Tobago. Now, this bill regarding the valuation of land amendment sets the foundation for the property tax that this Dr. Rowley-led PNM government wishes to foist on the population. And I want to start my presentation by reminding persons in the national community and, of course, members of this House, the economic circumstances which we find ourselves in, and also the financial benefits that may be derived from any tax, and make a comparison between what is being proposed with this eventual tax, because this sets the stage, as I say, Mr. Vice President, for the property tax, using figures. So if you look at the central bank, the Ministry of Finance estimates of expenditure, the revised and the final, 2008, taxes on property, the actual taxes on property that were generated amounted to $83.8 million. Total taxation revenue stood at $49.3 billion. So this tax on property stood at a mere 0.17%, or 0.2%, which is 2 over 1,000. For persons who may not be mathematically inclined, it is significantly less than 1% of the total tax revenue that the government would have generated in 2008. In 2009, we see a similar figure, even though the tax on property declined by only 12 million to 71.4 million. The total taxes collected by the government amounted to 31.4 billion. So a significant drop in taxes collected by government. But this taxes on property only stood at 0.22% of total taxes. So really and truly, the taxes on property for any serious administration contemplating financing the fiscal agenda, taxes on property in the history of Trinidad and Tobago really does not arise in any significant manner. Now, one can argue it may more serve an administrative purpose than a revenue-generating purpose. So, because really, what do we seek to do? What is the spirit of any taxation policy in this country? There may be other jurisdictions where their legislators have differing opinions on the role of taxes. But the way in which taxes are administered here is a function of the spirit of that. For example, so let me finish this analysis before I give that example. For example, in 2010, when we looked at the 2010, the property tax was proposed by then Patrick Manning administration, who is now joining our ancestors.
I allowed you a little leeway to sort of tie in what you're saying to the land valuation bill that is in front of us. I'm hearing you talking about property tax, and I just want to remind you that you can run afoul of the standing order dealing with anticipation of bills that are to come. The land valuation bill and the property tax bill are being debated separately. So I would like you to focus on the land valuation aspect of the bill that's in front of us when you're making your contribution. Thank you.
Thank you, Mr. Vice President. So in essence, the spirit of taxing and land really starts with an understanding of what land is. And the bill before us really sets some parameters. We have included multi-household dwellings, Mr. Vice President, to widen the net, if we may, to present to the country an opportunity to increase tax revenue. And one of the main issues that was raised, and I'm glad for your guidance, and I will bring this up in the next debate, right? But the only thing I want to say is that really and truly, we should not be thinking about revenue when we are dealing with this issue here. We should be, because taxes on property and does not generate significant revenue for fiscal policy in Trinidad and Tobago. Now, one of the main issues that was raised today by all sides, I've heard Senator Roach mention it, I've heard the Minister in the Ministry of Finance, albeit I have some challenges with the Honorable Minister's understanding or articulation. The issue that we have is equity. Now, if we look at some of the literature, and this one for the record is an article titled Review of Local Government Rating System in Fiji, a preliminary study by the Pacific Rim Real Estate Society at an annual conference in Adelaide, 21st to the 24th of January, 2001. All right, so as the history of land valuation is concerned, it's fairly recent. It said that in dealing with the demerits of an assessed annual value system regarding rental value, and I quote with your permission, Mr. Vice President, another effect of the rent control is that it distorts the distribution of the tax burden. In effect, rent control constitutes a de facto exemption of the older properties from the property tax. I have some issues with that, and they continue. This shifts the tax burden onto more recently built properties. The owners or occupants of a new structure are, in effect, subsidizing the tax for the older properties. So let me paraphrase and break it down for the average Trinbagonian listening. The Honorable Minister in the Ministry of Finance, Minister Allyson West, stated, one of the things the Honorable Minister stated, Mr. Vice President, was that this bill will empower young professionals, and I'm paraphrasing. I stand to be corrected if I am paraphrasing incorrectly, will empower young professionals to engage in the market regarding the property market. All right? Now, but if I want to submit that if you really want to help young families, the real issue is to fix the bureaucracy that pervades regarding the purchase and holding of land and property development in Trinidad and Tobago. A new law on an old system that does not work provides no solutions. So it's a new law with a failed old system. It fixes nothing, Mr. Vice President. Now, I'm taking my time because this issue is something that has brought great consternation, confusion amongst the population. I had one conversation with a member of the Association of Real Estate Agents, and what basically came out of that was they were confused. Their members were confused, and because of the vagueness of the information coming from the government, they are at odds to clearly define what exactly should be the guidance they can give to their members. And these are the real estate agents, Mr. Vice President. So if the persons charged with, the persons who are involved in the purchasing and sale and the articulation of valuations by valuators to the final buyer, who are the real estate agents, themselves are at a loss to explain what is coming out regarding the legislation, the average citizen should be further at sea. So it is as a result of that that I'm taking my time to develop the points. Now, so Mr. Vice President, so getting back to that initial article that I cited from the review of the local government rating system, they said that the new structures basically face an inequitable tax burden. And that ties back in to my first point, that all contributors to this bill spoke on the issue of equity. Now, this bill is definitely crafted not in an environment where equity is the main consideration. Members have quoted ad nauseum the clause regarding the increase from 500 to 5,000. I don't need to add my opinion there, because it is clear for all that that 5,000 may be someone's savings for 2 years. If there is a household that is on minimum wage, or if it's a single parent who is a clerk in the public service, a junior clerk in the public service. So if you're a junior clerk and your salary, your take-home does not cross the minimum taxable range for an employee, you will be at pains, really and truly, especially if you're a single parent, to add anything else onto your list of expenses. So, Mr. Vice President, in the interest of bringing some level of general understanding to the specific income constraints of the small man, I have taken it upon myself to bring a simple example of how $500 may be an onerous charge and how 5,000 will be significant.
Senator, at this point in the debate, we have heard a lot from other senators that have contributed before in relation to the point that you're developing now. Even in your contribution, you just indicated that you've heard it over and over again. You're going to run afoul of the standing order on tedious repetition. If you have other points to develop in relation to the bill that's in front of us, I do invite you now to bring them forward, but we've heard quite a bit in relation to the point that you're making right now.
Okay, I thank you. I guess that's the benefit of going down the batting order, Mr. Vice President. Now, so land tenure systems and market data. Okay? So there's another article from the rental value versus capital value, alternative basis for the property tax by William J. McCluskey and Michael Bell of December 2008. And they are making the point, Mr. Vice President, that the choice of tax base should ideally be linked to the land tenure system and the most common form of landholding in a country. It has already been established that we are not blessed with a common form. There are many different forms, and it may be difficult, really, to ascribe a particular method to either. So that is a challenge, and that challenge, I must say, is not being addressed, especially based on the contributions of members before in the legislation. Now, I want to turn to an important aspect of taxpayer perceptions. And I need to read this because I have not committed it to memory. Mr. Vice President. Under any tax system, taxpayer understanding is central to having an acceptable system. The basis of the tax and the transparency of its assessment needs to be easily understood. So, a good example of the lack of taxpayer comprehension was the use of the hypothetical gross annual rental value system that was used in England for residential property. This hypothetical gross value was based on very few actual rents that made it difficult to explain to taxpayers simply because they did not relate to the value of their house to an abstract hypothetical rental value. That would be the rather they did not relate the value of their house for the Hansard. So, Mr. Vice President, despite continuous attempts by the Minister of Finance to explain the system, there is no clarity. It has brought no comfort to many persons. It has definitely not brought comfort to some members of the Association of Real Estate Agents, who should by now be comforted and be well established in the rubric that will be used to arrive at any tax. Okay? So the entire nation, in essence, is held in suspense. So I leave that there. And if we are to understand that taxpayer perceptions is integral to having an acceptable system, then we must admit that there is a significant problem with this current bill. Now, Mr. Vice President, there's another point on equity, since this is the common thread I've chosen to apply in my presentation. In public finance, there are two perspectives on equity. This article continues. These are the ability to pay and the benefits received principles of taxation. Now, I would not go too much into the benefits received because that really would form my contribution for a bill to come, which we already went through. All I would say is this. If all the taxes go to corporations sold and they don't come back into your community by virtue of the legislation, then in essence, persons would feel at pains to even pay taxes on property. That's number one. The other thing is the ability to pay. Many members went through this point. And I remain guided. And by your gaze, I know that I won't run afoul of the standing orders, Mr. Vice President. But really and truly, there needs to be a consideration for persons who cannot afford. And if that is not there, then this tax is not equitable. This bill is founded on a foundation that lacks an acquaintance with the principle of equity. Now, so I move on, Mr. Vice President. I want to make some points, because this bill is a matter of public import. And I think I want to make this main statement. If we are to be concerned with the publics and their ability to develop, we must be concerned with their main concerns, which would be the income pressures on households, rising unemployment. All right? We have already seen a significant decline in the number employed based on the statistics presented by the central bank, which you would have gleaned from the CSO, as at 15 months prior. Since this PNM government has come into office, we have already lost nearly 20,000 jobs, if not more. And that's 15 months ago. We don't have recent data to go by, because clearly the situation has not gotten much better since then. So if we are to accept that this is the environment that we are living in, and we are to accept that the economy has significantly declined, continually, and we have to accept that businesses are facing continuous closures. We must understand that any new tax, given the current taxation regime, must bear that there may be persons who definitely will not be able to afford. So many persons prior, Madam President, as you have returned, mentioned some other issues regarding the tribunal. And because that has been hit ad nauseum, I would not be able to venture there. But there are some points I want to raise regarding the mechanism of annual rental value. Let's picture a scenario where we have an elder citizen. This person may have been very industrious throughout their working life, but they may not have been privy to a pension. So their circumstances has resulted in a situation where the only pension they can glean would be the senior citizens grant, which is $3,500. And whatever else they may get from family members who may be in a position to assist them. But during their time as a worker, this person may have spent their time building a family house with probably 6, 8, or even 10 bedrooms, which is common in many areas in Trinidad and Tobago, Madam President. But now they find themselves with only $3,500 and spiraling medical bills, which, in the absence of any support regarding CDAP and what have you, they find themselves hard-pressed to even eke out a respectable standard of living. And then you add on top of that annual rental value. And when the assessors come to their homes, they see that, okay, you have 10 bedrooms, and you have compartments. There's about 3 compartments because they would have built for a son and built for a daughter and so on. And they assess them at $10,000 a month, $120,000 a year. They take out the 10%, $108,000. And then they take a percentage of that. They may not be able to pay this, which would amount to just over $3,000, Madam President. They wouldn't be able to pay that because really and truly, they're already living on the margins. Some of them are hoping to play a mark, as we say in Trinidad and Tobago.
And they tax that too.
To be able to, they couldn't tax that. NLCB went against that.
Oh, good.
So they living day to day. When they go to the shop, it's a half pound of sugar, a quarter stick of butter, or margarine, sorry, that they'll be buying. A little bit of salt. They might exchange some eddos in the yard for the neighbor's green fig. These people, Madam President, cannot afford anything else, any new imposition which would significantly and negatively affect their well-being. So there's a point I want to bring out where this is concerned. Now, Madam President, really and truly, when one looks at this bill and you consider the environment of taxation that we are currently faced with, one really grieves for the average man. There was an article that surfaced in the newspaper, that would have been Friday, August 25th, 2017, in the Guardian, Trinidad Guardian newspaper, written by Joel Julian. Simply reportage. Valuation assessors ready to hit the road. Now, if one considers logic, we are saying in this bill that once 50% of property or land, is valued, the the commissioner can inform the authorities that the lands in Trinidad and Tobago are valued, Madam President. Now, why are we doing it that way? Why don't we take a concerted approach if really the issue was to get a full understanding of the property situation in Trinidad and Tobago so we can make significant and sound economic decisions? Why isn't it that a full census is the approach that is taken of all the lands in Trinidad and Tobago, and not you start? So essentially what they are trying to do is change the wheels on the car while the vehicle is in motion. I'm not sure how successful the government will be with this because, number one, the people of Trinidad and Tobago are fed up. They are fatigued.
That's right.
They are tired with the level of taxation, and they will give little cooperation in the current scenario. If, however, the people would have been consulted, and in this system, we believe that representation is important when taxes are to be imposed. If the people would have been consulted, Madam President, the government would have found that a simple reversion to the methodology and the regime that pervaded under the land and building tax system would have made sense and would have been something that would have been more palatable. Potato. I went presentation college and we see that. So, Madam President, the reality is this. The people of Trinidad and Tobago are tired. I am confined by the standing orders, so I believe I want to look to wind up my contribution. But I want to say this, that I want to echo the sentiments of members on this side. That if we ignore history, we will be doomed to allow history to repeat itself. And we'll be doomed to commit the errors of history. This PNM administration went out of office in 2010 on the heels of a tax on property that the people were not prepared to accept. And should they bring this back, they will find themselves in the same fate of the then Patrick Manning-led PNM, now the Dr. Rowley-led PNM. Thank you very much, Madam President.
Parliamentary Secretary, Senator Avinash Singh.
Thank you, Madam President, for the opportunity to contribute in this debate. A bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803. Madam President, it's been a while I had the opportunity to stand here and contribute, and it would really be remiss of me if I didn't offer my thanks to some persons for me being here today after a long while. Madam President, in contributing to this debate, I had the opportunity to get some rest time, as we want to call it. And in that rest time, during my little incident that had me down for quite some time, I, like many senators in this chamber, would have had the opportunity to speak to a number of persons at all levels. And I, while on medical, I also was at work, exploring the options of persons, you know, with bills to come. I was doing my homework even at the medical bed. And like many senators in this chamber, spoke to some persons. And, Madam President, the general consensus out there in terms of property, and when we are speaking here to the valuation of property and the valuation of land, that will lead to the next step, which that bill, if we was able to debate both of them together, would have been so successful in getting the points across, and we would not be in the position of having to repeat and offer answers to questions that, you know, will arise. But the point, Madam President, is that a lot of persons in this country have had significant challenges in knowing that as a nation like Trinidad and Tobago, where we have a civilized democracy, that taxes have been, waived, and persons look towards the public sector for goods and services. And, Madam President, it has to be paid for, as the Attorney General indicated earlier. And this is one of the ways, Madam President, for us as a civilized population to understand goods and services must be paid from the coffers of the state. And this decision, Madam President, to look at the Valuation of Land Act today may not be a popular one, but I indeed say it is a responsible one by a responsible government, because it comes at a time when the current Valuation of Land Act dates back to 1970. And Madam President, that's some 50 years ago. And that existing law, Madam President, allowed for inequity in the rates being applied across the board, as there were significant disparities in valuation dates and, by extension, valuation rates or values. For instance, the rate of tax was significantly different for properties under the Municipal Corporations Act, since they conducted valuations at various times, Madam President, and they were considerably ahead of those under the Lands and Building Tax Act, in which lands carried a flat tax rate and required no valuation. Madam President, where we had flat or sometimes mountainous or even swampy land, they carried a flat rate based on the size without regard for the nature or location. This resulted, Madam President, in a plethora of valuations for property in the country that did not reflect the true value of properties in question. Madam President, I would spend a few minutes speaking on two major points that most senators, have had challenges with, and I would just like to share my few comments on both. And one being the importance of removing these inconsistencies and lack of clarity where the Land Valuation Act is concerned. And I will spend a few minutes illustrating and demonstrating this point in relation to agricultural landowners and to help clarify the process and how that process works for the agricultural sector where land valuation is concerned. And I will also stick up in and add my comments in relation to the tribunal. Madam President, this whole issue of removing the inconsistencies, Madam President, the bill before us is very, very simple and mainly to clean up pieces of the legislation that already exists and to harmonize the way in which we view all categories of the taxes, be it agricultural, residential, commercial, and so on. But, Madam President, I want to ask a question, and it goes directly in terms of the conversations that I had with many persons in public. The opposition in today's debate contributed in a manner and a fashion that alluded to the population is crying out about the excessive or the burden of excessive taxes on them, and more so this property tax, or the way in which we are going to value or put a value to land, Madam President. But I want to ask that question, Madam President. When last any one of us in this chamber and elsewhere paid taxes in relation to our property? And so when we debate in a fashion that says this bill before us here today is going to stampede on the rights of our citizens where property and land is concerned, we must be careful, Madam President, to take note of how much money as a government we have had to forego because of the waivers with respect to this legislation in going forward. And I assume it's in the vicinity of $1 billion. So when the Attorney General this morning indicated that goods and services in this country have to be paid for, Madam President, I could tell you the entire budget of our ministry, my ministry, the Ministry of Agriculture, Land and Fisheries, could have been run out of the taxes collected from these sorts of legislation, $1 billion. So, Madam President, it's incorrect for the opposition to come here today and say it's thousands of dollars in taxes. The ordinary man in the street cannot pay this tax. Because this, Madam President, has not been put to the test. So we can't say that. And in all demonstrations, Madam President, when you look at the way in which this Valuation of Land Act is going to come into effect, and the transparency of this legislation, Madam President, again, I want to applaud the Minister of Finance and the Minister in the Ministry of Finance for taking this bold step. Some may call it biting the political bullet, but the point I'm making is a responsible decision because this country needs it more today than ever before in terms of our position and economic climate. Madam President, I referred earlier about land valuation in the agricultural sector. And you know, if one were to really listen and take note of some of the points made by my honorable colleagues on the opposition bench about taking this piece of legislation, throwing it away, repealing it, don't bring it here, and all of that. Madam President, you would think they actually care about the population. But when you look at the agricultural sector on the existing valuation and legislation, Madam President, it's repealed with inconsistencies. And what do I mean by that? When you look at the valuation, the current land valuation, and the way these taxes were looked at, Madam President, in Port of Spain, in the city of Port of Spain, when you look at the residential, commercial, industrial percentages, all 10%. In some areas, Madam President, in fact, where I live, Shogunas, agriculture under the existing land valuation, under the existing legislation is categorized under 10%. So if what Senator Mark and the opposition senators, his colleagues, are saying, that they care about the population, they care about the agricultural sector, Madam President, we are proposing a 1% on agriculture across the board. So that alone could tell you where the minds of this government is heading. We are serious about the agricultural sector. And when I speak to the agricultural sector, Madam President, where land valuation, when we came into office, because you can't talk about valuation without getting the whole land tenure issues right. And when you look to what we inherited as a government when we came into office, something the Honorable Minister, our leader today, has had to deal with in the Ministry of Agriculture, Land and Fisheries, where land is concerned, Madam President, it is scary. But I want to place on record that ably as he is, the Honorable Minister that is, has had to work some late nights, early mornings, and long hours to put structures and strategies in place so that we could reorganize and link land tenure and fix some of the issues where land leases are concerned. Because persons are questioning, okay, well, how are you going to develop figures or rates for agricultural land, Madam President? Let me declare my own interest. I am a property owner. And in the valuation of my property, one doesn't have to look far. I am the holder of a PTA, a probationary tenancy agreement. And in that, I am required by law to pay some $400 per acre per annum. And that's a good place to start. So what I'm saying, the more people have in the agricultural sector have leases in their hands, that will, in essence, organize the land management division of this government in terms of property matters and land matters. Streamlining will be easy, and it will be able to help us as a government. It will be able to help us to issue more leases so that all of these persons coming on stream will be able to come under the relevant legislation and contribute to the national coffers. Madam President, this will also assist us in terms of managing rent collection. Because I could tell you, a lot of persons in society are having challenges understanding, well, they want to pay something for the property that they are living in. They want to pay something because they know in their minds when they pay something to the state, that is some form of security. And to get there, we have to value that land and property in a manner that would be transparent and efficient. Madam President, so when you look at the agricultural leases, as I mentioned, we have given out some 5,000 leases upon entering office. And all these persons now could be brought under the umbrella of the government in terms of land and having the land valuations done and be effected. So when you look at the agricultural sector at 1%, Madam President, as opposed to the opposition's contribution to leave everything as it is, or don't bring no land tax, or don't bring no valuation of tax, land tax, and so on. We are harmonizing the entire country and making it equitable so that farmers all over the country now will benefit from the proper value and valuation done in the properties or the acreages that they are on. And I have mentioned, Madam President, in my case, $400 per acre, and in essence that will calculate down to some $4 per annum, which is less than half of 1 pound of sweet potato on the retail market right now, Madam President. So you understand the point I'm making, where we speak about it's going to tax you out of your lives and you are going to be on the streets, Madam President, but it's extremely far from the truth. Madam President, while I'm on this matter, I would like to indicate that as a citizen of this country, and we are talking about the way we value our lives, the way we value our land, and so on. As a citizen, my household, Madam President, we pay $3.38 a day for water. And, Madam President, I'm told that sometimes, you know, in most countries in the world, when you compare, and the Minister of Public Utilities here, he could attest to that. That's probably the lowest in the world, or close to the top 5 in the lowest in the world.
Yes, it is.
Madam President, so when we speak to how hard life is, I understand life, Madam President. I come from a rural community, just like my friend Senator Big, and I understand what this type of legislation will do, but I also understand, Madam President, from a responsible point of view, that this has to be done. This has to be done for effective government to really give back to the community, and we call some communities poor, we call some communities vulnerable, but it has to be paid, Madam President. So I'm saying that the agricultural sector under the Land Valuation Act will not suffer under this administration, because we are going to be fair, we are going to ensure that unlike the current Land Valuation Act, where some of these lands were categorized under the land and building taxes or the Municipal Corporation Act, when that is harmonized now under the valuation of land, Madam President, it will be fair and it will be across the board. I will spend 2 minutes, Madam President. I didn't really want to respond to Senator Big in one of his remarks, but he did say, in regard to the tribunal, Madam President, that the tentacles of the politicians is going to be coming into the tribunals, Madam President. I want to assure Senator Big that that is not the case with this administration, and he probably, you know, may have been accustomed to the operations of the last administration. Because if he simply turned to Clause 25G2, that would direct him and answer his own question, where it says, the minister shall not give directions to the valuation tribunal in respect of any particular application or proceeding before the valuation tribunal, or a direction that would derogate from the duty of the valuation tribunal to act judiciously. Madam President, so when we as senators come here and speak like that, a lot of persons are looking on, Madam President, and when we speak like that without reading and understanding legislation. And I am no attorney, Madam President, I'm a farmer. So, and that is my understanding of that clause. But I wouldn't say no more on that. Madam President, in this country, persons have the right, and they have the right to go and get legal counsel, they have the right to a number of things. So when you try to ascribe that type of negativity towards, tribunals and groups, this is no different to a number of tribunals that His or Her Excellency appoints. And in this case, when you speak to the minister appointing the members of the tribunal, Madam President, there are so many pieces of legislation where the office of Her Excellency is called upon to appoint. But really and truly, when you look at the legislation, it is really the cabinet. So is it that we are going to look at all the pieces of legislation and make those types of remarks and ascribe those types of behavior because you are accustomed to that style of governance under your own administration and paint everybody with a brush, Madam President? I think not. But they certainly do it. And, Madam President, that certainly the population have seen through and will continue to see their actions. Madam President, I did say I was going to be short, and I want to indicate that I would lend my 100% support to the efforts of the Ministry of Finance in getting this country disciplined in terms of our actions, and I want to commend the Honorable Minister in the Ministry of Finance for piloting this bill here today and making sure that our country becomes more, becomes more responsible in the actions that we take. Madam President, thank you for the opportunity, and may God bless all of us.
Minister of Trade and Industry. Thank you very much, Madam President. Just where my colleague ended, I'd like to start, and that is by complimenting the Minister in the Ministry of Finance, the mover of this particular bill. And I also want to thank all of us would like to thank the members of staff, the administrative staff who worked on this. You have no idea. This has been some years in the making, and they've been working extremely hard, and contrary to what has been portrayed on the other side, they have been sensitizing the public on the whole question of land valuation and the property tax. So we're very pleased here to bring forward these two bills, the property tax amendment bill and the valuation of land amendment bill. The big pity is, of course, that they're not being debated together. Very, very disappointed in the opposition that they have not agreed, as was done in the lower house, to in fact debate both these bills. I'll sit for a while, please. Senator Hussain. Okay. Okay. Continue, Minister. Thank you very much. Thank you very much. As I said, I'm clearly very disappointed that the two pieces of legislation were not taken together. And I mean, again, this shows the inflexibility of the opposition. And this really amounts to time wasting. And in terms of and I know what they're trying to do, to delay the passage of the bill. And some members on their side would have had great difficulty in separating the two issues. Indeed, the speaker before the last, spoke very much about the property tax and how onerous it will be. And of course, the leader of the opposition bench, Senator Wade Mark, also spoke about all the draconian measures, etc. And that's not what this bill is about. This bill is about land valuations and not about the property tax. So you have created all of this unnecessary work here today. And of course, as you're always trying to delay the passage of any bill, you just do not want the government to move on to complete their bills, and we will do so by sitting regularly.
6, please, imputing improper motives on the members of the opposition.
Yeah. Minister, yes. Refine what you're saying, please, and move on. Okay? But we will continue, Madam President, I take your advice, we will continue to support the Honourable Attorney General in the passage of all of the bills that we have on the legislative agenda, and we will press through to ensure that we complete as many bills as possible before the end of this parliamentary session. As I said, again, a very alarmist approach by the opposition. I've listened to comments by both the opposition and the independent bench. There were good points raised by the independents, but as usual, the opposition was very alarmist in its approach, referring to the legislation as backward. I'm quoting them, and I want to say, well, this is what precisely this piece of legislation is about. It is about curing the very backward pieces of legislation, curing the very outdated pieces of legislation, getting rid of all of the confusion, all of the irrelevance, and all of and generally the inequitable nature of the existing ancient legislation, to make sure that we put forward on the table proper legislation, comprehensive legislation, detailed legislation, Madam President, and that is what we have done today. So this is there's no negativity in this at all. Again, it's a very, and I'll speak to the attributes of the bill. I think the work that has been done is extremely good, and I will speak later on about the attributes. And so the whole question of, I know what this is about, and it is about the property tax, and Madam President, I'm not going to go into the debate about that, but I want to tell them there are 174 countries in the world that have a property tax. There are 18 countries in the world that do not have a property tax. You Google it, and you could choose where you would want to live. But what we are doing is normal. There's a responsibility of citizens to pay a property tax. This bill before us, the land valuation, is about that. This is about assigning values to properties so that a property tax can be attached to these properties based on the valuations. That's what it is about. And we could have very easily talked about both of them. But anyway, this is your way. You have your way. We still get a way. The legislation will be passed. But as I was saying, there are few countries in the world that have not done what we are doing. And 18 countries. Trinidad and Tobago is a modern, progressive society under this government, and we will move to modernize our architecture, particularly our land architecture, or land use policy, or land administration. That is the ethos of this government, and particularly with the two ministers, the parliamentary secretary and my colleague to my left, Senator the Honourable Clarence Rambharat, in place. That is going to be the approach, and of course with the AG to pilot the necessary legislation. So this is not about autocracy and authoritarianism and about corrupting practices and draconian legislation and so on at all. This is very simple legislation. You brought a version of it sometime in 2013. The Honourable AG had made reference to the legislation which was brought by the then Minister of Finance, Larry. Brought no legislation. Well, when you're ready to speak, you will speak. Or if you ask somebody else to speak after me, and you could clear it up. Okay? But the point about it is, yes.
Please, if there's to be crosstalk, it's supposed to be undertones. I'm not supposed to be hearing everything, so much so that I'm not even hearing what the minister is saying. And this is the last time that I'm going to get up and make this intervention. Okay? Continue, Minister.
Yeah, thank you very much, Madam President. And as I was saying, I lost my train of thought. The idea behind it is to, and this is just a step in the right direction, it's just the beginning, as I said, to have a really modernized land administration system in place. And of course, and I'll speak about the Ministry of Trade and Industry with regard to the commercial, industrial, and agricultural assessments, land valuations, etc. But to the bill at hand, and there's not much that can be said about it, but to say that I think that the bill is well constructed. This is a bill with clarity compared to there was I think it was Senator Hussain who said that this bill was clouded. This bill is not clouded. This bill is pellucidly clear. There's clarity, there's fairness, it is well constructed, there's owner protection, property owner protection embedded in the bill as well, so that there are, and I will go through and I will speak to some aspects. When I make those claims, I'm going to justify it by the particular clauses in the bill. And as I said, there's not a long bill, there's no need for me to go into much detail. So and I spoke just now about clarity. And if you go to the definitions of the bill, and the new definition on owner, very, very clear on who an owner is. Owner or occupier of any land, and if I can quote, Madam President, or the receiver, attorney, agent, manager, guardian, or committee, and it goes on. Clarity on who is an owner. So it really avoids any confusion in terms of the interpretation. It is very, 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 very clear. No ambiguity at all. Ambiguity at all. And then even if you go to the whole question of where, when you there's the inclusion of a new subsection which addresses where, what property, and it goes on in the bill to say the building occupies separately from other buildings, a location on a single parcel of land. It speaks to single dwelling accommodation. B, it speaks to single commercial accommodation. It's very, very clear as to what properties that we are talking about. And what I want to tell you is that previous provisions that made no, I think, and I can be corrected, but I do not think that the previous provisions made any kind of accommodation or provisions for apartment complexes and condominiums and so on. So those persons may have gotten away and may have been exempt. I stand to be corrected. But in this bill, there is full clarity as to what is embodied under this piece of legislation, and that is what I like about this bill. The whole question of fairness is another matter, and fairness in terms of the appeal system. And the bill addresses the appeal system, the question of the evaluation, appeal tribunal, the fact that if it is that the house owner is unhappy about the way that his matter has been treated by the valuation tribunal, that house owner could in fact go on to the High Court and then on to the Court of Appeal, and there's further redress right up to the Privy Council. So again, I say that in addition to clarity, there's fairness in this bill. There's fairness in terms of Clause 8. And Clause 8, Madam President, allows for the Commissioner to revalue any land that he deems to be over or undervalued. Again, fairness in favour of the property owner. The Commissioner can revalue any land that he deems to be over or undervalued. And, of course, such valuation must be sent by post. Notice of any such valuation must be sent by post to those residing in Trinidad and Tobago no later than 15 days, and those residing abroad no later than 30 days. But again, fairness to the owner. And, of course, Clause 11 speaks to the whole question of a situation where owners may be dissatisfied with a valuation. Again, there's a clarity, there's a fairness. And Clause 11, which will amend Section 19 of the Valuation of Land Act, lists actually 6 additional areas of objection for owners or local authorities who are dissatisfied with a valuation. And these include, for instance, and I will not detail all of them, but the annual rental value of the land appearing in the valuation roll is incorrect or unfair, then of course, there is recourse in terms of the land not being included in the valuation roll, the land omitted from the valuation, the land included in a series or complex of land units as a single land on the valuation roll should be listed separately on the valuation roll or removed. Again, there is recourse as well. So Clause 11 seeks to amend Section 19 of the Valuation of Land Act here. So wherever the valuation rule is incorrect, again, there is redress. So this bill speaks to clarity, fairness, flexibility. It puts flexibility in the hands of the property owners where they are objecting, where they are dissatisfied, where they're concerned. There is opportunity for fairness and for redress and so on. And again, in terms of owner protection, Clause 12 of the bill inserts a new subsection 3 under Section 20 to allow a person to appeal to the tribunal in the case where the Commissioner fails to determine the objection 12 months after service of notice of objection. Again, what are we speaking of here? Protection for the public, protection for the owner. right? So, and of course, where the commissioner fails to treat with an objection, the tribunal can, in fact, immediately start to treat with the matter after a 12-month period. Again, clause 15. And Madam, I'm taking the pains, Madam President, to speak to the actual clauses so that the opposition can understand how very well constructed and property owner friendly, I could say, this bill is. And I know they would not agree with me. But clause 15, for instance, seeks to introduce the whole question of the valuation tribunal and of course all of the elements that go with the operation of this tribunal. Again, the functions of the tribunal are not only to hear appeals in respect of valuations, but also to include adjourning proceedings to allow parties to negotiate between themselves to arrive at amicable settlements of objections. Again, this is saving money. The opportunity is there so that for almost, I can say, alternative dispute resolution. You can discuss the matters, the opportunities there to arrive at solutions amicably. And again, and then so on that in itself is a cost savings, and the idea behind that, and I say cost savings because almost 80 to 90% of the matters will be in fact dealt with by this valuation tribunal, so quite inexpensive. And of course, there's the benefit of the minimization of litigation. And of course, the other attribute that is commendable, but it's expected and is commendable, is the fact that this tribunal is fully independent, right? So, yes, there was a comment that the process is not clear. I want to say to you that the process is lucidly clear. And as I mentioned earlier about the outdated land administration system and land use policy and so on, and inherent in that, Madam President, are serious challenges for investors and commercial owners of properties. And I make this point here as Minister of Trade and Industry, and having a ministry having some responsibility for investments. And this is a step in the right direction. I can tell you, as it is now, it's almost a nightmare for any for someone wishing to access lands that are not couched or and are not housed under ETEC. If it's under ETEC and ETEC has a head lease, it's fine. You can go ahead and after all of the processes of negotiations and so on, you could go ahead and actually issue a sublease. Where that is not the case, and in fact there are many instances of commercial properties residing on agricultural lands, and these are to be converted to commercial properties. There's also a preference in many instances where persons may wish to occupy agricultural lands for commercial properties, but the process is a very cumbersome and onerous one, and of course, and the values that are existing is almost unheard of. You're talking about sometimes in cases of values under $10 and ridiculous values because these things were just never given attention to, and all of these things are deterrents to investors, local and foreign, unless they, of course, as I said, they can find property under couched under ETEC, then it becomes difficult and cumbersome, and you have to work through some of the nuances. And I can tell you that there's an investment to facilitate. There's an investment facilitation committee which I chair. And one of the responsibilities under that is that we can work through all of these nuances, all of these faulty systems, all of these deterrents that really will turn anybody off, any potential investor, from probably occupying lands that are not housed under ETEC. And I can tell you I go through great pains as minister as well, and I work very well with the Minister of Agricultural Lands and Fisheries, and we actually sit with the Commissioner of State Lands in many instances, and we go through the number of issues that are outstanding as with regards to commercial property or agricultural commercial property or potential properties where commercial entities would be housed. So small step, but a step in the right direction, because these are matters that we must give attention to. The whole question of land administration, land use policy, etc. And I won't go to talk about Tobago, but we do know that it's a topic. These are areas that must be addressed and that this government is addressing. And so, as I said, this is about getting the process right. This is about the property tax, implementation of the property tax, and we will have to speak about that on another day. But at the same, or we may start it today. I'm not sure. But the point is, this is about getting the process started. They've wanted it separated. We have separated it. And here we are talking about the amendment bill, the valuation of land amendment bill. The idea is, let's get this going. There's a point that has been raised by many people about the 5,000 non-compliance. I think it's 5,000. About the 5,000 non-compliance in Clause 5 of the bill, which seeks to amend Section 6 of the Act, which is to increase the fine from 500 to 5,000 for property owners who fail to file a return of land. And many people have said that it's onerous. But it's the government's opinion that this is not unreasonable. And the idea behind it is that this is paying your property tax and, of course, getting this valuation done as a prerequisite is an obligation, and it is 5,000 because it's meant to be, it's meant to avoid evasion. The idea behind it, it has to be a deterrent. Don't do it. It's a responsibility that we all have. As I said before, there are 174 countries where there's a property tax, and there must be some system of valuation of properties embedded into the whole system of paying taxes, so that it's an obligation. And it's not, contrary to what was said before, it's not just about revenue earning. It's not, as you rightly said, it only contributes to about 1% of revenues. So it's not strictly about revenue earning. It's a responsibility that is assigned to you as an owner of a property. And in return for it, the infrastructure, there's expenditure on infrastructure, roads, drainage, etc., etc. So that there is return. So there is return for the house owner. And again, you try to show the severity of it by saying this old person, etc., etc. In many cases, it's not one person in that household. It's several persons who live there and who have an income. So it's not just about this single pensioner in every property that has to pay these large sums of money. It's not that at all. And of course, when we get to the property tax, there is in the event that someone is incapacitated in some way or cannot pay the tax, or there's good reason. There's the property tax amendment allows for that, and we will deal with that then. But as it is now, all of the discussion about the $5,000 in the event that someone fails to return of land is to instill, in my view, the importance of this obligation. It's an obligation, and I don't think that anyone must try to evade. As I said, the proof is in the pudding. 174 countries do have it. I've spoken about the land matters for commercial use. Madam President, the delays, the kinds of assurances that we are unable to give to potential investors, and it is why we must get on with the business of land valuation on its own. Get on with the business of land valuation. Get on with these amendments so that we can move on to the next piece of legislation, which is to put the property tax in place. Get rid of all of these bureaucracies. That's what we're working towards. In the Ministry of Trade, I can tell you that I'm an industry. The ministry is working on a number of reforms, working with all of our colleagues on this. And this is not the time for me to detail them, but it's about reforms, it's about fixing our institutions, it's about fixing our agencies, it's about getting things right, it's about having clarity, it's ensuring that there's that Trinidad and Tobago is a modernized country, that people would want to come here, want to invest here. It's a place to do business. We can, in fact, and I know that the statistics do not show well now. The point is there is commitment on this side to fix and to repair and to ensure that we leave in place. And we're not going anywhere, as a matter of fact, but to ensure that we are building proper systems so that Trinidad and Tobago, it becomes an enviable place. People want to come here, live here, etc. Right? So this, Madam President, is my short contribution to support the Land Administration Bill, being very careful to veer on the side of what is before me and not what is to come later on. Thank you very much.
Senator Haynes. Thank you, Madam President, for the opportunity to contribute to an act to amend the valuation of land
Chapter 5803. Before I get into the substance of my contribution, it is indeed my pleasure tonight to go after the Minister of Trade and her rather interesting style of debate that we had tonight. See, the Minister read the clauses of the bill and then proceeded to repeat, to tell us that it's well constructed and that it's fair by just reading the same document that we had. And so you read, but okay. What we have is that a number of arguments, because it's late in the night and we started early this morning, and a number of arguments were made by our bench, by the independent bench. All of those arguments were ignored, and just what we looked at, so the minister just looked at the legislation that we all read, and we all raised our concerns from what we read. So we know what's in there. What we're saying is we disagree. So I was hoping that the minister would have put on the record why she felt it was well constructed, rather than just reading verbatim what was there, because we disagree that it's well constructed and that it's clear and that it's fair. We disagree. All right? So the minister also repeated that it is about getting the process right, and let's get this going and let's move on. And I'm going to get to some of that a little later on, but I just really want to address something that seemed to be of great bother to the Minister of Trade and Industry, that the opposition decided that it was not in the best interest of the people of Trinidad and Tobago to debate the Valuation of Land Act and the property tax together. And I'll explain why, because it's not mischief and it's not us being inflexible, but rather, as Senator Baig noted, we have been meeting with the people of Trinidad and Tobago. And what we are doing here today is a reflection of the voice of the people of Trinidad and Tobago. And as such, what the minister views as time wasting is really what we would like to view as a responsible approach to making legislation. Because what we're doing here, right, this is not something that should be. And I had to address this since the anti-gang debate. But this idea that legislation ought to be passed through quickly. Legislation and policy are different things. Legislation is meant to be an enshrined part of your country's administration of justice. So what we're doing is something that is meant to stand the test of time, and so it should be meticulous, it should be well scrutinized, it should take time. It's not something that should be rushed through and just get on to the next one, because that is the essence of irresponsible governance. And if you did things like that, you would find that we would be back here trying to fix it, because, and that brings me to something Senator Singh said, which Senator Singh went into pains to say that this bill is very simple. Given the number of contributions we've had today and the number of interventions, even by way of amendments from some of the independent senators, it's not that this bill is very simple. They would like for us to believe that it is simple, but it's not the case, because it is wide in scope and it affects every citizen of this country and it affects our future. And so when Senator Singh said that this hasn't been put to the test yet, I just would like to inform the senator, through you, Madam President, that we are talking about people, not guinea pigs. So that if you don't have a sense of how this will work and how this will impact everyday citizens, then you simply should not do it. Because you cannot come here and say, well, let us put it to the test when you are talking about the lives of people in this country. I don't think that would go down well when you face the population. I don't think that they would appreciate the sentiment that they're testing out something on you, because they're very uncomfortable by this bill. And I can tell, yeah, they are. Because in our consultations, because we held consultations. People, pardon? You was watching it? Yes. So we held consultations, and since 2017, as a matter of fact, we've been holding consultations with people on this bill, the budget debates, and a number of other things where these issues came up. And again, interestingly enough, the Senator Singh sought to tell us, to give us comfort on this issue of the tribunal. And in trying to comfort us, he directed my colleague, Senator Beg, to the section which he said that the valuation tribunal, that the minister cannot impact on the decision of the valuation tribunal. And he said this is the comforting area of this legislation. That's the check and that's the balance. However, managing to skim past that the minister can suspend the members of the tribunal, right? So section 25B1 says the minister may suspend a member of the valuation tribunal from the office on the ground of misbehavior or physical or mental incapacity or for cause. You see, that negates your check at the end, simply because if you are dependent on this person for your job, this check that we're hoping that the minister will not impact on the decisions of the valuation tribunal when there is a symbiotic relationship between their job and the minister and who is putting them in that position. I mean, you are promises are comfort to a fool, and we in Trinidad and Tobago are not fools, so we're not comforted by what you're saying. You see, what the point that most of the speakers before me sought to make on this issue of the tribunal is that it's something that we've all heard, that justice should not only be done, but should manifestly and undoubtedly be seen to be done. So to have an executive that we have seen over time come here with different pieces of legislation seeking to increase their executive power, do it yet again in another piece of legislation, any piece of legislation that affects the property rights of the citizens of Trinidad and Tobago. And then that same executive that is concentrating power in their own hands is telling us that they included a check in the legislation against themselves, and that we should be comforted by that because they'll do the right thing, is ludicrous at best. Right? I cannot understand. And what I find to be particularly appalling is that in the face of contribution after contribution after contribution from different members. Now, mind you, I understand that it is their instinct to wish to ignore the opposition, and I believe that's to their detriment, to be honest. But you can go ahead, right? I mean, but that you had an independent bench come here today and say time after time and give reasons why, not simply just read out pieces of the legislation and say, I disagree with this and sit down, but give reasons why this is not something that we should have on our law books. And to have government speaker get up time and time again and say, and no one actually, you see, all you're saying is that it's in here and that you'll be protected. But the issue of mistrust between the people and the government still obtains. So you have not comforted anybody. You have not convinced us. But the trick is today that you don't need our votes. So you will railroad this through. Exactly. Through this house. And you will have your way. But I've said it before and I'll say it again. You do have to face the population of Trinidad and Tobago. You will have to face the population of Trinidad and Tobago. And Senator Singh said it, that the Minister of Finance, what he said, bit the political bullet to pass this. I mean, that's interesting. Because that means they know. They know that this piece of legislation that they will railroad through this upper house. Not in the same manner they did in the lower house, but because we've had...
I don't think that is something you should be saying in that to try again, refine your language, okay?
I wouldn't say, I would say this piece of legislation that they do not need our votes to pass, that they will have their way and have passed through, will have repercussions. And I think that the government is aware of it. And that's why when I sat and I listened to all the speakers before me, there was a very interesting bit of narrative that because there were words that you heard repeated. The Minister of Finance was at pains to say that this legislation is reasonable, that it is equitable, and that it is responsible. The Attorney General repeated the reasonableness of the legislation in their view. And I believe that the reason they were at pains to repeat those words is because they know that the sentiment within the nation is that this legislation is not for the people of Trinidad and Tobago. and so there was an exercise here of one group of persons, despite varying arguments against, to convince, and could only be to convince themselves that they're doing a good thing. So I had a few words that I thought I would also put on the record. Is it fair? Is it compassionate? And when you pass legislation like this, is it I guess it is reflective of the government's priorities. Because again, the government has said, and well, the Minister of Trade said one thing. She said this is not only, the minister said, this is not only about revenue collection. And the parliamentary secretary from the Ministry of Agriculture said a different thing, that this is about revenue collection and that you need roads and drains and that people, you have to get money and it will go back into the communities. And that disjointedness is something that they would have to work out amongst themselves. But the point is that the sentiment on the ground is that this PNM government has no clue how to earn money, how to earn revenue. So what they do is ride on the backs of the citizens with taxation and bills like this. So what you say, so the citizens have said that the government does not have the ideas to produce and to earn, so you are taking the benefits of my production and what I have earned and the property that I have bought and the value that I have added to society. And you are going to use that and say, look at what you've created by way of revenue collection. And that is wrong. And it also, the people of Trinidad and Tobago also do not trust the government to spend their money wisely. So that when you say, yes, we will. When you say, yes, we will, I agree with you. When you say to us that we are bringing this and it will help your communities, you have had 2.5 years to help the communities if you were going to, and you have not yet. We do not believe that you will. And I said before, the scope of this bill is wide and that it will affect all of us and it will affect our future. And Senator Creese raised an important point that formed a significant part of my thinking about this piece of legislation and some of the pieces of legislation, the work of the government in total. Senator Creese said that it was troubling that this legislation did not seem to have an overarching philosophy. Now, again, interestingly enough, that there's as an independent senator in the bench, in the upper house, and there's a space to create balance. And where we are in a two-party system, but the United National Congress has been saying that this PNM administration is an administration without a plan. Now, what Senator Creese said is a reflection of what we have been saying from the onset. because you and the population is aware that these, as Senator Mark called it, movements backwards, these backward pieces of legislation, are without an overarching plan for the development of our country. And you can see it in the way that it is crafted and the way that it is brought to the various houses, that they really don't know where they're taking us. They are just carrying us for a ride, and I mean, we will see in 2020 or before. Onto some of the concerns I had about the legislation. As the Minister of Trade noted, that there's this impetus to move forward quickly. And one of my major concerns, because as I said before, this bill will be passed without the help of the opposition or against the grain of a lot of opposition from our bench. The Ministry of Finance's Valuation Division, once you pass this, are they ready to implement the legislation? Because you see, again, we have seen pieces of legislation come here in a rush. Let's get this done. This will save the country. This is what we need. This is the absolute savior. And it all stops at implementation. After you've passed it, what do you do? And we've seen time and time again that the answer is nothing. So it is appearing to be that the Parliament is being used as part of a PR mechanism that will pass legislation and check it off as an achievement when there's no implementation. So it is inaccurate to say that you've achieved anything if you pass the law and you have not implemented it. So when you look at the Valuation Division and the role of the Commissioner of Valuations, which is quite extensive, and if you look at the parent law, that the Commissioner of Valuations is responsible for making sure that each parcel of land, every parcel of land in Trinidad and Tobago, including buildings, plant, and machinery for all purposes required by the government, subject to presidential exemption from such valuations, that they have to be prepared to do this bulk of work. And we have additional work coming their way, and no indication from the government if the Valuation Division is adequately capable to treat with the massive workload that will ensue once this bill is passed and proclaimed. You see, Madam President, despite our vociferous opposition, because they don't need our votes, they'll pass the legislation. But no one has gotten up to tell us what the implementation process would look like, the timelines for delivery. None of these things came forth in this debate. So on one hand, they did not seek to tell us why the legislation is good for the people of Trinidad and Tobago. And then on the other hand, they did not tell us how it was going to be implemented and rolled out. The Minister of Trade told us that despite what we are saying, that there was a public relations and public education campaign. Now, you can say that, but if you cannot show the benefits, if you have citizens, if you have senators still asking a series of questions about the legislation, then it means your campaign quite simply did not work. And so you have to go back to the drawing board. It is your responsibility as a government, if you are going to pass legislation, to make sure that the public is adequately aware of their responsibility under the legislation, and as well as that the government is ready to fulfill their role under the legislation. And it is my respectful view that they are not ready. I'd like to refer to a newspaper article from the Guardian newspaper on Friday, 25th August, where the title, Friday, 26th August, 2017, property tax evaluators receive certificates. And in this, they're talking about the 187 assessors that have been trained in a 6-week period you had in that article the Ministry of Finance Permanent Secretary, Michelle Durham-Cassoon, saying that tax administration in this country needed to become more efficient, and that 187 persons graduated as valuation assessors training program. And the 6-week program originally started with 207 participants. So if you look at the Schedule 2 of the Act, you will see the forms that the valuation assessors would have to go out with. And it's a lot of private information. And it is you have to hope that once you're doing this, that the persons that they've trained in 6 weeks will get this right. And that's not casting any aspersions on anyone within any training program. But it is saying that if you're going to do something, you should at least be at pains to do it right and not just do it quickly because it seems politically expedient for you to get it done now. You have to be able to tell the population of Trinidad and Tobago that the persons you are sending out to collect their data and their information are persons that you have properly trained, properly vetted, and that we have to be able to trust that this is true. And if we cannot do that, then this whole system will fall apart. And again, it is not sufficient for you to just say it, but bring evidence to support the fact that this was done in a proper manner, and that the persons that are coming to collect my information, that you as the government will stand behind that person and their qualifications and their training. You know, who will be ultimately held accountable? Where are we just hoping that people will be fair and honest and transparent in carrying out their duties? I've seen time and time again, when things fall apart under this government, there has been an attempt to always pass the buck, to blame someone else. So is it that if my data, if my information gets in the hands of different people or is not used for the intended purpose, will you simply just blame someone else, or will you take responsibility as a government for saying that these people have been trained and properly vetted, and therefore you stand by them? You see, this is serious business. And people are concerned about who is coming into their homes. We also live in a high crime society. And so you have to be aware of these things before you just simply say, okay, there was a 6-week training program and here are the people, and give them your information, because that's the right thing to do, and that is your role as a citizen. In my preparation for today's debate, I looked at the Hansard from 2009, and the late Dana Sita Senior Counsel, may she rest in peace, had stated that the entire concern of the country, I think, a substantial concern is that how this is to be determined, that there's that is illustrative of the lack of trust. People say, well, I'm not renting any property. Of course I know, and I'm quoting here from the Hansard, of course we know that that's not the point, but you are looking at the value that can be had for the property were it to be rented. Now, the point being, who has to say and how is it to be determined? What is the annual rent of the particular land? Not forgetting that the land includes buildings, etc. So way back as 2009, the question of the mistrust between the government as an implementing agency and the people of Trinidad and Tobago surrounding these taxes were articulated. When you bring back the legislation 9 years later in 2018, no attempt was made to correct these shortcomings. So again, we're saying if you had intended to do this, and we knew you intended to do it because it was in your manifesto and you never denied that you were bringing it back, at least take the time in between to try to fix the shortcomings and do it right. A number of my colleagues raised the issue of public consultation. And I'm not going to go into any great detail, but I would say that there have been many questions surrounding the transparency and the fairness of the process. And the universal cry of the people of Trinidad and Tobago is how much more can we really take? And we're hoping that, well, I am hoping that the government will, for the first time, exercise some humility and listen to the voices of the citizens, and that don't simply say there's enough information. If the people are telling you that there's insufficient information around the valuation of land process, then it is my respectful view that you should listen to that and try to correct it, because it's not a difficult fix. I would also like to point out that if you may recall, when the furor around the submission of forms occurred last year, the commission was not able or equipped to deal with the number, well, according to the information they provided the public with, that they were not equipped to deal with the people who were scared or forced to submit their valuation forms. So what we saw were hundreds of people standing in lines. Right? I remember in front of Palms Club last year, there were just people standing in front of Palms Club with no information, with their forms in hand, just kind of hoping that somebody will give them some kind of guidance. And so what we're saying is, once this is passed, are we going to see a recurrence of this? Or is this system designed to execute and exercise this process more efficiently? You see, and I think Senator Richards raised it. Again, this idea of the social contract. So it's not just how you'll spend our money, but if you are putting this in place, is it going to be done in a fashion that the citizens feel accommodated by the institution as part of the process? Or are we going to be fighting?
Senator Haynes, you are now starting to repeat what you have been presenting earlier. So I will ask you to tie in what you have to say and move on to some new points.
Yeah.
Okay.
So I would just like to just wrap that up quickly, if possible, really quickly. So the idea is that there should have been, we're hoping that there's rigorous planning around this. And when you talk about spreading the burden of adjustment, we have questions. Is the government adequately prepared to bear their burden under this legislation? And are you ready to facilitate the population of Trinidad and Tobago? The other points I had, I think, were very clearly articulated by earlier members, which included the onerous $5,000 increase. And I would just like to add my voice to the voices that went before, that the increase seems to be excessive, and we do not agree with it. And I think, and again, on the issue of the tribunal, I would also like to add my voice to that disagreement. And taking all of these things into consideration, Trinidad and Tobago is looking on at what we do here and what the government is going to do. And if we vote on this tonight, your vote will be recorded, and that information would be transmitted to the citizens of Trinidad and Tobago, that you have said that you have heard their concerns, and now you have chosen to ignore the concerns of the people of Trinidad and Tobago, and that you will face the repercussions for that. So I thank you.
Minister of Agriculture, Land.
Thank you very much, Madam President, for the opportunity to join this very important debate. And Madam President, let me right off address the heart of the contribution of Senator Haynes. And I listened to Senator Haynes talk about, and Senator Bigg, talk about the consultations they are currently conducting across the country. Since 2017, you're right. across the country, and I commend you for that. But I want to position my contribution, Madam President, on this issue of land, because we cannot have property tax and valuation if we don't have land. And at the heart of what needs to be reformed in this country, whether we look at it from a housing or institutional or commercial basis, at the heart of what has to be addressed in this country is this issue of land, particularly the ownership of land by the state and state agencies and the administration of that land. And I want to open, Madam President, by referring to the issue of consultation and Senator Haynes's point about we don't need to rush the legislation. We need to take our time with the legislation. And it is consistent with what I've heard in the last 2.5 years. The United National Congress in opposition, at every opportunity, calls for consultation, joint select committees, affirmative resolutions, and a variety of checks and balances and so on in opposition. And perhaps, Madam President, as Senator Haynes now gives this government advice, perhaps that is the reason why the UNC established what I consider to be a remarkable record in their 5 years and 2 months, Madam President, and I will continue.
Yes, the acting leader of government business.
Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favour say aye. Aye. Those against say no. The ayes have it. This Senate will continue to sit until the completion of the business at hand.
Thank you, Madam President. Madam President, let me refer to the United National Congress track record on this issue of land and this legislation that Senator Payne says we should take very slowly. Well, this is beyond slow. 2010, May 24th, they came into government. In 2010, the calendar year, 9 pieces of legislation were passed. Not one dealt with the issue of land. The closest you came to in 2010, your first year, was an amendment to the Land Tenant Security of Tenure Act, where you deleted 2 words and substituted those 2 words for 2. In 2011, you passed 20 pieces of legislation. None dealt with land. In 2012, you passed 17 pieces of legislation. None dealt with land. The closest you came in 2012 was an act to incorporate the Association of Real Estate Agents, Act number 10 of 2012. That's the closest you came. In 2013, you passed 14 pieces of legislation, none relating to land. State land, administration of state land, land management, land valuation, property valuation, 0.
And a whole new ministry.
In 2014, 16 pieces of legislation. Well, in that year, you passed a piece of legislation called the Planning and Facilitation of Development Act, which made some changes to the town and country planning regime. That was only partially proclaimed. If you want to take half a point for that, go right ahead. And in your final year, 9 pieces of legislation passed by you, not one dealing with land. So it seems as though, as the minister responsible for hunting, Madam President, the United National Congress and government is like a mannequin facing the headlights. They freeze. And once returned to opposition, they have the advice for everybody. We don't need that advice, Madam President. In our first 2 months in government,
Nothing to tea.
in our first 2 months in government, on November 13, 2015, we brought before the Parliament an act to amend the procurement legislation. And in that act, we reversed the problem that the Minister of Planning and Sustainable Development under the UNC faced. And that is the famous or infamous Invaders Bay matter. And in that piece of legislation we brought on November 2015 was an amendment that says in the disposal of property by the state, dealings with state lands must be included. And that was the first step. The first step was to recognize once and for all we needed a legislative regime to address the dealings by state and state officials in state lands. And when we talk about disposal of state lands, we had a very broad definition that included leasing, renting, or anything that meant that the state gave an interest, beneficial, legal, or otherwise, in state land to someone else. And in 2016, 2017, Madam President, we brought 4 bills dealing with land, straight on land, including the amendment to the State Immunity Act, including the amendment to the Land Tribunal. In 2017, 2018, we brought 6 bills. So in 2.5 years, Madam President, we've already brought 11 pieces of legislation dealing with land. Because you cannot talk about valuation and property tax if you're not talking about a fundamental change in the management of land in Trinidad and Tobago, and that is fundamental. Madam President, I think you were out when most of Senator Mark's contribution, I'm not sure. I just want to address some of the speakers who went before me. And I want to refer, Madam President, to this paragraph. It's from the Hansard record of the Senate on Tuesday, 29th December 2009. And I quote, Madam President, "We call on this government to either withdraw this measure, send it to a select committee of the Senate, where we would have large-scale and proper consultation, but do not try to foist this bill in its current form down the throats of us in this Parliament today. We are speaking on behalf of the hundreds of thousands of people who cannot speak for themselves, and we are here today representing them, and we are saying this bill is oppressive. This bill must be withdrawn. And if you do not withdraw it, you pay the price." And I'm quoting Senator Mark, Madam President, on the valuation of amendment bill. So, Madam President, these threats we've heard today are not new to us. If these threats are not new to us, unlike the UNC, which sat in government for 5 months and 3 years, 5 years and 3 months, and passed 85 pieces of legislation, none of which address the matter of land, you could cry mayhem in the streets and what and what and what. We intend to bring this to this Parliament and place before you the legislation that will fundamentally transform the way in which we manage lands and the way in which we deal with the matters of valuation and property tax. But, Madam President, I listened to my friend, Senator Mark, a man who a few weeks ago threatened to lay down his life for my freedom of expression. And I want to address two specific issues he raised in relation to this bill. And this is this matter of the Tax Appeal Board versus the tribunal. And needless to say, he's reversed himself. Because in 2009, he was saying, they're going to delete the appeal board, they're going to delete the tax appeal board.
You're talking like me, man.
Yes.
You remember the little fella, the plane is coming.
And he was, Senator Mark was saying they want to delete the appeal board and put the tax appeal board. And here it is, we have 600,000 at that time, 600,000 properties to be valued. And there were only 3 judges in the tax appeal board. And when the board was established, it was never anticipated that you'll have this avalanche of complaints. So he set aside the proposal to move to the tax appeal board contained in that bill and said, we need an independent land tribunal. And I'm prepared, Madam President, I'm prepared for us to argue the issue of independence. But what I'm clear is that Senator Mark in 2009 was prepared for a land tribunal instead of the tax appeal board. And Senator Mark in 2018 is prepared for the tax appeal board and no form of tribunal. And Madam President,
you are confused.
No, I'm very clear.
Madam President,
the person who is most confused right now, because I think I have been saying this ad nauseum about the crosstalk. Okay, continue, Minister.
Madam President, and I take very seriously anybody who would lay down their life for me. And it's a sense of duty I feel to assist my friend in remembering. Because, Madam President, when I first saw this bill and I heard my colleague, Senator MP Allyson Singh, debate in the other place, one of the first things that drew me to this bill was this issue of the inclusion of condominiums, apartments, and townhouses, and so on, in the bill. Because I was around, Madam President, this is my 25th year of involvement in land in this country. And I was around when people were first addressing in this country the issue of wanting to dispose of an apartment that was contained within a dwelling. And because we do not have strata legislation and townhouse legislation and so on in this country, they found difficulties in doing it. And over time, we've evolved, and we see the proliferation, and MP Allyson Singh talked about Aranguez, which is an area in which we've seen agricultural land being built upon, and townhouses and apartments being developed. And again, I found it was a very important part of the legislation that we were able to ascribe to each apartment owner and each townhouse owner and each condominium owner within a residential complex a property tax, which, Madam President, in the normal form of a property tax, represents the contribution you make towards the physical infrastructure and the services that support this asset that you have. And then today I listened to my friend, Senator Mark, questioning the government's intention with the inclusion of condominiums and so on. And I went back to his contribution on Tuesday, December 29, 2009. And this is Senator Mark, Madam President. Mr. President, I want to ask the Minister in the Ministry of Finance, given this definition for residential land, how would you define apartments? How would the Minister describe and define One Woodbrook Place? How are you going to tax those people given the definition of residential land when it says a single dwelling accommodation that you are permanently occupying? That is what they mean by residential land. What about those areas where you do not have a single dwelling unit? What about apartments? What about condominiums? What about One Woodbrook Place? What about townhouses? In your rush to bring the legislation, you may have overlooked this particular definition or these categories. We need to revisit this definition. And Madam President, that is what this bill is all about.
That's right.
And if Senator Mark must support one amendment in this legislation, this bill, it will be the legislation in section clause 3 of the bill where we seek to amend section 2 by inserting subsections which include single dwelling accommodation and all of those things, which include elsewhere in the bill, Madam President, his wish for condominiums, apartments, townhouses to deal with his friends in 1A Woodbrook Place. And Senator Haynes, Madam President, has said that the government does not listen. It may have taken us 9 years to hear you, but we are here tonight in furtherance of your wishes to have property tax attached to apartment, condominiums, and townhouses. Exactly. So, Madam President, in looking at Senator Mark's contribution, the similarities from 2009 are clear. In fact, Madam President, I'll close on dealing with Senator Mark's contribution by saying, even his joke about the government wanting to tax people on boats made today was made in 2009. Madam President, let me address some points raised by Senator Beg. Madam President, I really was at a loss and I tried my best to focus, but I could not understand. Senator Beg referred to Schedule 2, where in putting the information forward for the purpose of having your valuation assessed, you are required to say what is the registered deed or certificate of title registration number. Because, Madam President, that is the way this works. As I said at the start, you can't have property tax and you can't have valuation without a property. Whether it's an apartment which has an address in a building that is built on land, because we're not going to have many boats with people to tax, built on a parcel of land, and it is the fact of the land that triggers the valuation and the property tax. So that I could not understand, because, Madam President, my friend spoke about his various areas of expertise. And maybe he has not been involved in conveyancing. But the deeds and certificates of title are a matter of public record. And if we wanted to know anything about a parcel of land, you can go to the district revenue office where the rolls are kept, and you can check the records. or you can go on your own or through a search clerk at the Registrar General's office, and you can get the information, because it is not anybody could get a certified copy of a deed, could get a certified copy in the case of RPO land, of a memorandum of transfer, and any search clerk could extract title information from a certificate of title. So it does not create any risk or bring upon anybody, because one can snatch a certificate of title. Surely you could do that. But one cannot lift a parcel of land from Guayaguayari Road in Rio Claro and cart it off in the night, depriving somebody of the property. And part of the administration of land and what we seek to do in dealing with both land valuation and property is to minimize the risk of people interfering with people's legal rights by occupying, by squatting, by interfering with title and committing fraud with land and all those things. So I don't see the problem in that. And Madam President, I was even more astonished by his criticism of the definition of owner. Because, Madam President, there is a reason why this dictionary meaning is not used in this legislation. There is a reason. Exactly. Because in the definition section, you include terms for which you are varying the natural, the legal, or the meaning to which people have gotten accustomed. And Madam President, this is not a totally new definition. This is along the lines of the definition in the 2009 amendment. It is, of course, an expansion of the definition of owner, which was in the original Valuation of Land Act. It is an expansion of that. And the only reason it has been expanded and the only reason it is here is because it takes into consideration, this definition takes into consideration at least 8 forms of ownership rights that may be exercised. So it talks about the owner, and that would be your dictionary or the meaning which is normally described to owner. It talks about a receiver, recognizing that during a receivership, the ownership of the assets rests by virtue of the court decision to appoint a receiver, rests in the hands of the receiver. So the receiver, who is required to either run the affairs of the asset or dispose of it at fair market value, has to do that by functioning as an owner. The third one is attorney, and attorney there refers to somebody who holds a power of attorney. And it is not unusual in our society for people to hold a power of attorney, which places them in the shoes of the owner in order to exercise the powers and functions recorded in the document which gives them the power. The fourth is an agent, recognizing the agency relationship between entities, individual or corporate entities, a manager, a guardian, recognizing, again, we may have circumstances where somebody is acting on behalf of a minor, where a minor has been granted an interest, legal or has an equitable interest in real estate or other property, and acts through a guardian because the law requires a minor to act through a guardian, or a committee. And a committee there is under the Mental Health Act, where somebody has been determined to be incapable of functioning on their own, lacking capacity to sign documents and enter into contracts. And that is why we have that seventh area in which we define ownership. And then lastly, someone having possession of something which allows them to exercise the right of an owner. So there's nothing underhand or anything. It is simply taking a definition which exists mainly in that form from the 2009 legislation, which itself was an improvement on the previous legislation, and inserting it into this bill. And there was another reference in the schedule, again, quite surprising, that Senator Baig would question the requirement that if you have a residential building under rental, that you provide the name of the tenant and the lessee, the current month rent, and so on, and provide the details. Because, Madam President, when you determine an annual rental value, this will assist the Commissioner of Valuation and the Commissioner's staff in determining the annual rental value. And it is information that has to be provided if you want to comply, and that is what we need in this country. We need compliance with the legislation so that we could, it's not a matter of generating revenue alone, that we could have certainty, that we could deal with fraud, that we could pass title from person to person, and we'd operate, because we have a way, Madam President, in this country, I've said it in different places, that we talk about, I receive a lot of YouTube videos about agriculture in Holland and how to do this in this country and that country and all of that. And I've always said to people, we want first world things in this country, but we do not want to adopt the discipline and the requirements of a first world society. And if you were in North America, for example, if you were in Canada, for example, and you receive your property tax receipt, when you pay your property tax, you would see a breakdown which tells you what your property tax is going to, your $50 towards the fact that there's a school in close proximity, down to the fact that there's a fire hydrant within 100 meters of your home. And it reflects that. And in our country, we could get there to that level of detail. But before we get there, we have to deal with the management and the administration of land. We have to deal with the valuation of that land, and we have to do with the scale that we'll use to tax those various categories of land. And that is why we are here. And this bill has not fallen out of the sky. 2015 November, we brought the disposal part of dealing with state lands. 2016-17, we brought 4 bills relating to land. And 2017-18, we have 6 bills in the Parliament dealing with land. And the government is moving in a particular direction, and we wish to have your support in doing so. Madam President, I also listened very carefully to Senator Hussain. And taking the cue from Senator Mark, of course, Senator Hussain raised the matters of, and just get my notes, raised the matters of the unfettered powers of the minister. Well, in this bill, Madam President, you will see that once the minister makes the appointment, the bill sets out what happens thereafter, the circumstances in which the person could be removed, the other elements of the bill, and it says that the tribunal functions on its own. And you know, my colleague Senator Khan always talks about this issue we have with giving the executive and giving ministers power. But we only have that issue when we're in opposition. And if you had passed any bills relating to land in 2010 to 2015, somewhere along the line, you would have figured out that in administration of matters in this country, ministers have to be given some powers. In fact, the Constitution is very clear. And the President issues an instrument giving a minister the power to exercise general control and direction over a ministry. And also, allows a permanent secretary to exercise those powers which have been given to the permanent secretary. Most importantly, the power of an accounting officer, recognizing that a minister should not be involved in the financial affairs of the ministry. So that this fear we have of dealing with executive and dealing with the minister, I mean, we could extrapolate the argument. You yourself recognize that where the legislation generally, unless the legislation gives His Excellency the President, or Her Excellency the President, a power to do something in their own discretion, the word president represents a cabinet. The cabinet is made up of politicians. You don't get to the cabinet generally unless you're a politician. So this fear we have of giving power to the minister. Now, I'm not saying that concerns about exercising influence and so on do not arise in the exercise of ministerial power. But that is in nature, and that is why, to balance that, we have a constitution that has enshrined fundamental rights in sections 4 and 5, and we have a piece of legislation that I've spoken about many times in this House, called the Judicial Review Act, which I said was really landmark legislation in this country to hold decision makers accountable, reflecting on a society where a decision maker had no duty to give reasons. So we've evolved. And the exercise, the grant of a power to a minister is balanced by several requirements elsewhere in the law that requires a minister or a politician to act, or any decision maker to act in a particular manner. And I listened to Senator Hussain refer to one particular tribunal or one particular instance in which he was saying that, you cannot compare a decision of a valuation of property to the registration of an architect. And a word comes to mind, Madam President, flummoxed. I hope I used it correctly, flummoxed. I was flummoxed. Because, Madam President, I don't really like to say too much about what went before. But the laws relating to the opportunity for professionals to practice is something I hold close to my heart. In fact, I hold it at a higher level than any property valuation. And I'll tell you why. I had the opportunity, Madam President, to be admitted and to practice in Canada. And there was a time in Canada, until the 1980s, in fact, you had to be a citizen of that country to be admitted to practice in Canada. And it is one Andrews, an immigrant coming to Canada or going to Canada and seeking admission to the bar after meeting all the requirements and upon being denied because he did not have citizenship, who raised the matter in the court, and ultimately the Supreme Court of Canada held that he was entitled to be admitted to practice. And were it not for Andrews, Madam President, I would not have been, because contrary to what people have said elsewhere, I am not a citizen of any country other than Trinidad and Tobago, and I've never held citizenship anywhere else. And I would not have been able to practice. And that is why wherever we have a piece of legislation or regulation or process or procedure that deals with the practice, the right to practice and the opportunity to practice something for which you have been trained, I hold that very sacrosanct. And I think the UNC should also do that. Because one of my predecessors, Dr. Kernahan Jones, made it to the position of Minister of Agriculture in this country, with responsibilities not only for the welfare of animals, but for responsibility for the practice of veterinary medicine in this country. And Dr. Jennifer Kernahan Jones could not be registered as a vet in Trinidad and Tobago because she studied in Cuba.
Yeah.
So I took note of that point, that it is not...
You have 5 more minutes.
It is not simply a subjective look at comparing rights and so on. What the Attorney General is saying and what we are saying in this legislation, when you look at 600,000 persons, parcels of land, and the different ways in which, and I'll very quickly tell you, I made a submission in our 2.5 years in government, there have been 4 reports already on the matter of land and land tenure in this country. 4 reports. 2 out of the Joint Select Committee on Land and Physical Infrastructure. I don't know how many of you are on that. 1, strangely enough, by the Committee of Foreign Affairs, and 1 from the Committee on Statutory Bodies. 4 reports tendered, and I had the opportunity to respond to all. And in one of the responses, I took the opportunity to share with the committee, and I will share very quickly with you, that this matter of land and land tenure, which ultimately affects valuation, is not a simple matter. Because I told the committee, just dealing with the areas for which I am responsible, and that is state lands, I categorized, I listed all the different categories of land. And I said in relation to agriculture, there is your traditional state land, and there are about 20,000 leases for state land, many of which have expired. There are state land acreages that are occupied, but for which the people have no tenure. There are former Caroni employees who receive 2-acre parcels under the VSEP. There are 8,885 of them. There are former Caroni tenanted lands, which were in the hands of people like cane farmers and so on. And there are also former Caroni lands which are occupied, but for which the people have no tenure. In residential, there are state tenancies across the country. There's state land which people occupy for residential purposes. There's the Caroni VSEP. The list goes on and on. In commercial, you have the Caroni, you have the state. In institutional, and I have not even touched on PSAEL, Palo Seco Agricultural Enterprises, HDC, Land Settlement Agency, and your Certificate of Comfort, and all the state enterprises, be it WASA, T&Tech, who own property, who hold property, some of them residential, in all forms and fashion, which requires administration in a way that we could separate into the different categories, deal with the issue of tenure, get a process by which we can ascribe a value to those property, get a scale on which we could determine what tax would be charged, and ultimately have a modern system of land management and land administration which generates revenue, brings certainty to both the owners and the landlords, and also creates a much-needed revenue stream to support the infrastructure and other development in this country. And I felt obligated, Madam President, at this stage, at this late stage in the debate, to make this contribution by virtue of a position I hold that gives me a particular advantage, and that is the minister responsible for land in the country. And I will tell you, it is not an easy task to bring these state lands under proper management and administration so that we could have certainty and we could protect the assets of this country. I thank you very much.
Senator Ameen.
Thank you very much, Madam President. I waited patiently to hear the contribution of the Honorable Minister of Agriculture, Land and Fisheries, hoping for some contribution, some part of his contribution to this bill, an act to amend the Valuation of Land Act with regards to land tenure. And we did get a very brief mention. But, Madam President, as we begin the discussion of the valuation of land, we cannot forget the discussion of security of land tenure, something that this PNM government has failed to do in its time in office. Madam President,
most of the mention that he made of any sort of land tenure regularization and security under the Land Settlement Agency, the HDC, Caroni lands, were done by the People's Partnership Government. But, Madam President, in December of 2009, the PNM attempted to enforce several contentious policies and oppressive measures relating to land, including property tax and valuation of lands. These measures were contentious. There were people marching, people protesting the lengths and breadths of Trinidad and Tobago. People lost confidence in the government. People lost trust, and the government lost the support on this and other matters. This assessment, this valuation of land affects property rights. It influences an owner's use of the land, an owner's ability to earn income from the land, or to influence the income itself, and how property rights could be shared or transferred. It interferes with the security zone and the comfort of citizens with regards to ownership of property. And just as it did then, it is now eliciting a reaction from persons all across Trinidad and Tobago. People of every social bracket, every economic bracket, every racial, religious, and geographic bracket. And just as in 2009, the population felt that the land valuation bill was rushed, that there was not enough consultation and input, not only from citizens, but stakeholders, that these measures will be enforced on citizens. Here we are, after months of the PNM being in government and having this intention, trying to bringing this legislation to Parliament once again without any form of consultation. Madam President, the history is on record in 2010, mainly because of this attempt to do land valuation and bring property tax. The PNM suffered an organizing defeat at the polls, and history was created when Kamala Persad-Bissessar became the first female prime minister, winning overwhelmingly that general election in 2010. And, Madam President, I sense an element of déjà vu. Here we are in 2018, 2.5 years later. 2.5 years into this term of this government led by Dr. Keith Rowley, with an attempt to reintroduce a system that they lost government on. Have they not learned any lesson? Madam President, the point about public consultation has been made by a number of speakers in this debate. And so I just want to add my voice without going further, lest I be chastised for repetition. But, Madam President, this Amendment of Land Valuation Act is one that any government which has the interest of democracy and citizens at heart must do engagement and would hasten to have not only public consultations, but initiatives to educate the public on its intention, even if it has no intention of listening to what the people say. And you know, Madam President, earlier today, while my colleague, Senator Hussain, was correcting the record after the contribution of the Attorney General left hastily. But I am happy that he had the opportunity to contribute, unlike other members of the lower house who are elected to represent a constituency, and unfortunately that debate came to a premature end. But today, Madam President, a ruling was made just around the time the Attorney General left. A ruling was made in the court concerning a matter that the government brought against former directors of HDC, and it involved land valuation. And the claim alleges that an evaluator attached to the Commissioner of Valuations accepted a bribe to value a 50-acre property at $180 million, ignoring valuations provided by independent valuators Lyndon Scott, who valued the property at $52 million. And the minister, Minister Young, indicated that the employee, who was an officer of the Commissioner of Valuations, allegedly received a bribe to value the land at a higher figure compared to that of the independent valuator. And the decision of the court, Madam President, in my humble view, reflects an incompetence on behalf of the Attorney General and the government in that in bringing this matter and having the court make that decision. To me, it strikes against a hard blow against the government. Madam President, the UNC has always indicated that we will support, and we are in support of a good, fair tax and good, fair land valuation system, a transparent framework. Earlier, the Attorney General quoted the former Minister of Finance and his quote with regards to recurrent land and building tax, if I may just reread the few lines. A land and building tax regime is a key pillar in all modern tax systems. Recurrent land and building taxes meet all the conditions of a good and fair tax. The current system of valuation brought by this government is neither good or fair, and so we cannot support it. I continue the quote, "The backbone of a successful land and building tax is the proper valuation of properties within a transparent framework. The framework presented, and particularly the method of appointment and disposal of staff of the people responsible for hearing objections doesn't lend to transparency, and so we cannot support it." The minister, then minister at that time, continued, "This will require the property rolls being brought up to date. I propose to phase in these taxes over the period 2014 to 2017, and consultations will be held with all stakeholders." We have seen no consultation from this government with regards to this measure. Madam President, at the time, the Honorable Minister indicated that it will be done on a phased basis. This government proposes to come, in fact, they started to collect valuation forms even before the legislation came to Parliament. And they had to be taken to court. And then they indicated to
Hussein, I will ask you to leave the chamber for 10 minutes, and you will return in 10 minutes' time. Senator Ameen, continue, please.
Madam President, the government started to do this assessment exercise even before the legislation came to Parliament. When it was taken to court and they lost in court, they then advised citizens that they can voluntarily submit valuations. The approach of the People's Partnership government at the time was to do in phase one, commence valuations of all industrial land, including plant and machinery. Then in phase two, to go to commercial properties. And in phase three, go to residential and agricultural properties, so that you wouldn't have the situation as you have now, a sudden rush of taxation on top of all the other taxes that this government has already brought. Madam President, the Attorney General also failed to quote the then Minister of Finance when he said, and it was reported in The Guardian of Friday, August 28, 2015, government has no intention of implementing the property tax and will seek to amend the amnesty if it is returned to power next month. So there are methods within our standing orders to treat with members who say things that are misleading, but I trust that the Attorney General will have an opportunity to correct the record if that was not his intention. Madam President, the Valuations Commissioner himself has indicated that has distanced himself from the attempts by this government to enforce this exercise on its citizens. In the Newsday of June 29, 2017, Valuation Commissioner stays clear. Commissioner of Valuations, Balde Ramuta, has distanced himself from media releases and the website of the Ministry of Finance, which provided information to property owners on requirements for the property tax data collection exercise. So I want to ask this government, where are you going with this? What is your intention when the bill is passed in terms of implementing? Madam President, I want to just go briefly into a few clauses to add my few cents to what would have been said already. Clause 4 of the bill will amend Section 5 of the Parent Act to clarify that the Commissioner of Valuation shall make a valuation of A, the site value and improved values, B, the annual rental value, and C, where necessary, the capital value. I want to ask, and I know that the Minister will come in her wind-up, what is the capacity of the Commissioner at present to conduct this exercise? And what measures are being put in place to improve in terms of where we are now, what is required, and to put the necessary systems in place? What is the role of the CPO in staffing and so on? Or are these staff members going to be appointed by the government or by the minister, as we have seen other measures in the bill? Madam President, Clause 5 of the bill will amend Section 6 of the Valuation of Land Act to increase the penalty for failure of the owner of the land to file a return from $500 to $5,000. Many of my colleagues have already indicated their objection to this steep and unnecessary increase. And I was so saddened to hear the Minister in the Ministry of Finance say that $500 is nothing. $500 may be nothing to certain people here, but $500 represents a week of food for some families, or in fact, some don't even have that much. But Madam President, while that point has been made, I want to tie that in to the Clause 6, which inserts a new Section 7A that requires the Commissioner, where he is of the view that more than 50% of all lands in Trinidad and Tobago has been valued, and that valuation should take effect, to notify the minister, who, by order, would then declare that the valuations are in effect. And, of course, when these valuations are in effect, it brings us now to the implementation of the collection of taxes. But I am asking here, are these penalties going to be in place even before this property rule is established? And this is just for the information of myself and for the public. There is a fine of $5,000 now it has been increased from 500, and for persons who fail to file a return of the land thing, right? So I am asking if you intend to bring in these penalties before, and what is the situation with citizens who have not had the opportunity to file. Madam President, a number of my points have been made already, but I want to just add in the new ones. I want to endorse what has been said in terms of the objection to the method of appointment of the Valuation Tribunal by the Minister of Finance and all the implications of political influence there. I also, Madam President, want to ask a question that has not been raised in the debate thus far. What is the role of the local government authorities in this exercise? What is the role of the municipal corporations? I have not heard a minister responsible for local government. I don't know if he will contribute, but I trust that perhaps even if he doesn't contribute today, he could look into this. In the original Act, Act 21 of 1990, there was reference to an assessor, and an assessor referred to any person appointed as such pursuant to Section 79 or to the Commissioner of Valuations under the Valuation of Land Act. That Section 76, which is in Part 5 of the Municipal Corporations Act, Act 21 of 1990, was repealed by Act 18 of 2009, Section 55, 56, and 57. And it is my view, Madam President, that there is a role for the municipal corporations with regards to valuation of land, and certainly when we come to the discussion on property tax, I will talk more about that. But our position has been echoed by Senator Avinash Singh, who spoke about property tax, the proceeds going to improve communities and going to improve roadways and facilities such as recreation facilities and so on. And it is my view that the municipal corporations must be given a clear role in these activities. Madam President, just a moment. Madam President, I just want to say a few more things with regards to local government. Local government is the arm of government that is closest to people. It is also very close to my heart. This, Madam President, is an opportunity for further decentralization. The People's Partnership held decentralization and devolution of power close to its heart in terms of its principles of governance, not only directly in local government, but with disbursement of state resources, providing services in every sphere, education, social services, and so on. And the opportunity to build the capacity of the regional corporations to conduct their affairs, to do assessments, later on to collect land and building taxes, whether you want to call it land and building tax or property tax, we will come to that in another debate. But the administration of that, based on the valuation, must be informed by a first-hand reality. And I feel that the state agencies or the government, the arm of government that is best suited to do that is the regional corporation. Madam Chairman, Madam President, I also want to just question the role or the purpose of this tax. For every measure that a government brings, it should tie in the measures in the policy or in the legislation to some bigger objective. The objective of this piece of legislation of doing land assessment cannot simply be to collect taxes or to improve or to increase the revenue of the government. What development does this assessment or this valuation contribute to in our society? Madam President, earlier mention was made of the different methods in terms of being based on property rental, the rental value of property, and the other methods, but I just wanted to point out some of the advantages of the different methods. Oh, sorry. Right. Which I have highlighted here. So I just want to go directly to the various methods mentioned. There was a paper done in Fiji, and it was actually done by the local government, and it was for, with regards to land management and the development department of the School of Social and Economic Development of the University of Southern Pacific. And their property taxes and so on are largely managed by the local government authorities. But in deciding how they were going to assess properties, they used methods that would drive development in a particular manner, so that the objective was not only to gain revenue for the government, but to influence development. So it was observed that the unimproved capital value or the site value basis of rating provided much more incentive for urban development. This may be relevant to some areas, even here in Trinidad and Tobago, where building development is still in progress and some old structures need upgrading. It encourages the landowners to clear obsolete and dilapidated structures off their land, providing incentives for redevelopment with new buildings or refurbishment and upgrading of existing structures. And so I ask in the government, apart from collecting revenue, what is your objective in terms of your development objective? What do you hope to incentivize the citizens to do by bringing these taxes? This unimproved capital value system provides an incentive for full utilization of the land so that the landowner gets better value if they really do utilize and develop the land fully. So there is no penalty in the form of higher taxes for making improvement to their property. The disadvantage, as in everything, there are advantages and disadvantages.
I mean, I have given you a lot of leeway, but I think you need to tie all that you're saying now, you've made your points, to the bill, okay?
Yes. All right. Oh. Madam President, I'm sorry. I want to mention two other methods. So I want to indicate that my purpose for doing this is to make suggestions, because in the Act, it is based on the annual rental value. And I am asking if consideration could be given. Well, in fact, Senator Creese, I didn't want to repeat the point he made, where multiple methods were suggested or could be used at the discretion of the authority. And I am saying that these are some suggestions that I would like the minister to take into consideration in terms of the method to be used and what incentives it could provide, apart from just collecting revenue. So some of the difficulties with this capital, with the unimproved capital value, is that the disadvantage of this system is that it would obtain accurate transactions of vacant plots in highly developed. Obtaining the information could be problematic in areas where you have a lot of vacant lots and transactions taking place rapidly. Gathering the information could be problematic. Also, it may be difficult to obtain sufficient rental figures for industrial and residential buildings, as they are largely owner-occupied. But for the commercial and industrial sector, capital value is derived from the capitalization of rental transactions, and the figures could be provided from the records of the occupiers, which would often be the renters. Another method is the annual value rating system. This rate is levied on the estimate of rental value of the property, which is being proposed by the government. And it deals with the market, the quality of market rental evidence. Well, this mention was made earlier as well, that it could be eroded over time. And you would have to do assessments regularly in order to accurately reflect the rental value of these properties, whether they are improved or they depreciate. Other difficulties, of course, with this system that is being proposed by the government now would include the increased level of owner occupation of properties and extremely active capital market. The rental is closely tied to its existing use rather than its best use. So even now, Madam President, the forms attached in the schedule in the Act asks the owner to submit what they think is the rental value. There is no incentive for the owner to use this building for some better purpose. In many instances, the owner will try to perhaps see what is the least they could possibly pay in property tax. So the use is really tied to really not the best use. The eventual use is not tied to the best use. Administratively, this system is complicated by the existence of owner-occupied vacant land for which estimates must be made, and in an area where no extensive system of cash rent exists. Senator Mahabir made mention of a rent assessment board, which is, I think, defunct in Trinidad and Tobago. Where does an occupier, get accurate information to suggest what the rental value of his property is? This system of valuation is suitable in a country where there is an active rental market, where information is available, where, as I say, the rent assessment board is actually operational. It provides, we need some sort of uniformity with regards to development that would allow the comparison of properties and sufficient development to provide the volume of data that is required. I don't believe that these parameters are available in Trinidad and Tobago, and this is what is being presented to us as sort of the premier option with regards to assessing properties. So, Madam President, if the Minister could just indicate, as I say, what the incentive, what the development incentive of this assessment is and would be, it would, I think, add value to the public information. I also want to implore the government, Madam President, this bill requires a simple majority. They will go through with it in spite of the objections from the opposition, from voices in the independent bench, and even in the public. But I think, Madam President, I hope the Minister could share with us what are some of the methods you have to educate the public about this exercise, what it entails. We have seen a battle of words in the media, public statements from the Minister. We have seen court objections going to court with regards to this attempt by the government to conduct an exercise that citizens are not properly informed of. And it is my view that a proper education exercise should be done before the exercise starts. There are many questions, and I think they have been raised in the public domain, but certainly when you engage the public, you will be able to answer the questions directly. So I want to implore the government, even though it has the power and it has the authority to go ahead and not listen to the public on this matter, that there really needs to be a greater level of education. I think they are past the stage for consultation. That should be done before the measures are brought to the House. But even now as it is, even we ourselves should have the opportunity to hear how the government intends to approach this. Madam President, I am concerned about the exercise itself in conducting the evaluations. I had a look at the forms. I myself have refused to submit the form. It is not yet law, and the government has sort of attempted to frighten citizens into submitting the form. And I think that sort of scare tactic being used by the government with a big stick over the shoulders of the citizens does not augur well. We already have so many taxes that people have no choice in. You told the population you would reduce VAT and you increased VAT. You have so many other taxes being brought. And here you have another measure where people are being frightened that they could lose their property. And so when the announcement was made by the minister, even before the legislation was brought, people were flocking to the offices in droves. It is clear from that exercise that the offices presently do not have the capacity to even receive the forms that are being submitted voluntarily. So I am asking what will happen when this becomes mandatory and people have to submit their forms. Are they going to be lining up in the hot sun, as we saw some months ago, waiting to submit this form? And if they don't do it, they could be fined, not $500, which is nothing, but $5,000. I have a serious concern with that. And so I'm sure the minister may make mention of that. But in the instance where a person may be willing, but they simply do not know what the rental value of their property is, what sort of redress, what sort of assistance, support can these offices provide? If they do not have the capacity to receive the forms as is, when a person is saying, listen, I don't know what the rental value of my property is, can you help me?
I'm sorry, but you are now really repeating what you said before, and you're also going back on issues that have already been raised by previous speakers. So I'm going to ask you now to either wrap up or raise a new point in your remaining time, okay?
Right. Okay. Thank you, Madam President. So I want to ask that I think that you indicate if any support is available to persons who are willing to submit their forms and they don't know how to determine the value that they should put on the form so that they will be treated fairly in the exercise. Madam President, I just want to close by saying that that the United National Congress has indicated that at some point the taxation of property is something that we must look at, but we cannot support the valuation of land exercise as is being done here today, Madam President. I know that the trend of the government is going in a very negative direction now, and I look forward to engaging the citizens as the PNM goes out of government to have a fair system of valuation and a fair system of taxation for all citizens. Thank you.
Senator Small.
Thank you very much, Madam President, for giving me the opportunity almost 11 hours into this debate to join in. And I have no plans to be here very long, Madam President. But I think it's incumbent upon me to be able to give a few remarks on the things that have been said today and share some of my thinking. Madam President, I think that I've looked at this. I've listened to virtually all of the speakers in some way or the other. And Madam President, I believe as a country, we are trying to move the country forward. And one of the things that we have to look at, Madam President, is the fact that we have systems in place, and those systems are archaic. Those systems would have been created years and decades ago. And I see this bill, Madam President, as one move of trying to modernize one part of the system. My other issue, Madam President, I think I'm on the record here in this chamber, I'm saying several times, and I will continue to say it. No piece of legislation I've seen in the past couple of years that I've been here is anywhere near perfect. I'm always willing to accept a 60 or 70% solution because it allows us to move forward rather than trying to refine it to the point where everyone is happy, which will probably never happen, because I've seen cases where people are happy with things and then immediately as it becomes alive, people have challenges. So we're here to debate amendments to the Valuation and Land Act. And this is a piece of legislation, Madam President, that alone by itself almost has no effect because it's linked to another piece of legislation, the Property Tax Act. And I think that, Madam President, the concerns expressed, there's one concern that I want to join in, and I won't go any further with it, but it has to do with the establishment of the valuation, the tribunal. I support the creation and establishment of the tribunal, but I have a challenge in terms of the minister having the authority to appoint that tribunal. And I've listened to the explanations provided by the Honorable Attorney General earlier, and I understand the position he's taking, but I think because we are going in a different direction now, we're taking valuation of land into a new forum and we're putting a more rigorous system in place. I think you have to marry some of that with what you're trying to do with the concerns of the people people at large, citizens in general. And I think by having those officers inside of the tribunal appointed by Her Excellency would give people the confidence that at least there's a high level of impartiality. And I think that's something that I would like to hear what the minister will wind up and certainly the AG if he gets to speak. What are the government's views on that? So, Madam President, I want to go quickly to a couple of things inside of the clauses. I think that with Clause 3A1, where it deals with the appeal of decisions to the Commission of Valuations, Madam President, the current structure of the Valuations Act is that you go to the Tax Appeal Board. And as a person who, in my other endeavors, have had to take a matter to the Tax Appeal Board, and 11 years later still waiting on a determination, it's just, and I'm not blaming anyone, but that's just the system. So that while I understand the views about trying to strengthen the Tax Appeal Board, and I am of the view on two fronts, Madam President, that having a tribunal will allow for a group of people to be dealing exclusively with valuation matters. So that's one. You allow them to focus purely on, so that your matter doesn't get lost in all the other matters that the Tax Appeal Board is dealing with. And then from a time issue, I don't anticipate that any valuation matter will go to the Valuation Tribunal and take 5 years. I do not anticipate that. So I think there's benefits and there's value in having a tribunal in place. So I believe that this provision is superior to what we have now, provided, of course, the concerns that have been placed on the table here around the method of appointment of that tribunal are addressed. Madam President, one of the key clauses for me inside of this amendment is that Clause 3, I think it's C, where we deal with the separation of accommodation in multi-dwelling and single-dwelling accommodation. This is very, very important. Madam President, I recall a couple of decades now almost, I arrived in the UK to study, and I moved into my ground floor flat. If I moved in on a Wednesday, the Thursday morning I got my council tax advice, and it was for occupant of the flat. And that's how the system is. You're the occupant, and that's just how it was a multi-tenanted facility. But every person inside or every occupant received a council tax billing. And it allows, it's even. And there's valuation because those, for instance, those who on the ground floor flat, because they had access to the yard or the garden, would have paid a higher council tax than those who were on a higher level. And for a long time, this current system we have hasn't been able to capture these multi-dwelling places. In many cases, these are multi-million-dollar residences, and people have not, in my view, been able to do or contribute their fair share to the tax coffers of Trinidad and Tobago. I think that this provision here closes that gap and allows for those who in many quarters could probably afford it the most to make their fair contribution to the tax base. And Madam President, I'm on the record here. My views on this are clear. Those who could afford to pay more should be made to pay more. Yeah, if you can afford $1 million condo, you can certainly pay your share of tax to the state of Trinidad and Tobago to make sure that all of us have access to these services. Madam President, I have a couple of more things. I don't plan to stay here very long at all. I had raised, Madam President, the issue of, I've noted that at clause 8C, where I have a concern about making sure that the application of this, in terms of notice being deemed to have been served within 2 weeks after dispatch. If we're working with TT Post, we have a challenge. And I think that there needs to be some understanding by the parties who are managing this. I think that on a previous occasion speaking here, Madam President, I had indicated that I had one of those persons who submitted my evaluation form. And the notice of receipt of same from the date on the outside envelope that it was stamped as dispatch, it took 11 weeks to get to me. So that we live in a place where systems are not efficient. First-class mail is not something that really works in Trinidad and Tobago. And my concern is here that something gets delayed. I have a good example. We received a document here today on our desk when we arrived, and it's from a particular institution on Independence Square, literally a stone's throw. But on the outside of the envelope, it's stamped Piarco Sorting Center. To go 2 blocks from here to here, it had to go to Piarco to come back to here. And I am not in the post business. But these are the things that we're dealing with here. And we want to make sure that citizens, or at least those who are applying it, understand some of the weaknesses or the failings of the current system that we have in place. So I have no great objection to the provision, but I want to make sure that in the application, the people understand the realities of the post system, or as best we have it in Trinidad and Tobago. One of the other things I like, Madam President, is that inside Clause 12, there's a provision that allows the tribunal to step in and treat any objection that the Commissioner has not treated with in 12 months. I think this addresses another major weakness of the current system, where things sit on the Commissioner of Valuation's office for all good reasons, I suppose, just the volume of activity. But this provision allows now for the tribunal to kick in, almost automatically to kick in and say, listen, it's been 12 months since you've lodged your application, let's pull these out and start to treat with them. And I believe that's a strength of inside of the legislation that I've seen here. Because, Madam President, the whole idea about the tribunal, which I support, I really, really support it, because I had sat at the Joint Select Committee dealing with the procurement, the amendments to the Procurement Act, and when we did the review board. And the whole mantra is that we're trying to move towards a system all around the world, including Trinidad and Tobago, towards more alternative type dispute resolution, where we can hopefully avoid litigation, which is costly in more ways than one, and not only in money, but also in time. And that while inside of the provisions, everyone still has the recourse to the High Court, I believe one of the other things inside of there is that the provision, I think it's somewhere in there, 25(1) A and B, it allows for the adjournment of the proceedings of the tribunal, so that the parties could be working out through a matter and then decide, listen, could we have a conversation outside of the formal workings of the tribunal to see if we can resolve this matter amicably? And I think that is something that, in the current way it is structured now, goes to the Tax Appeal Board. You don't have that opportunity. So for me, it presents or gives citizens who may be aggrieved or who disagree with the decisions or the rulings of the Commissioner of Valuations more options than exist now to treat it a matter, and perhaps in a more cost-effective way. So I like a lot of the provisions in here. I was excited to see them, because I'm saying this is where you are providing citizens with more than one way to treat this use, and allows them to be able to get a matter resolved, and try to avoid the normal adversarial way in which things are dealt with in a judicial system. Right. Well, Madam President, I also wanted to talk about the issue around, let me get my few notes here. I don't have many notes. Yeah. So I think that one of the things that stands out for me, Madam President, is that there's a provision that the minister shall not give directions to the tribunal. I was looking elsewhere to see where else there was a provision that says a minister can. There's lots of provision of what ministers can do, but I have struggled to find another provision where the minister can't do this. So I like it because on one level, but I ask a different question, Madam President. If you say that the minister shouldn't do this, what happens if he still does it? Or it's proven that he still did it? What happens in that case? And it's silent. I'm not saying it's something that is hugely, that I need an absolute response on. But by putting it in there, my logical brain takes it to the next step. That you say the minister can't do X, Y, Z, great. I ask, and if you're specifically saying he can't do this, what if it's proven that he did or she did? What happens then? And I'm not sure. There's no penalty or anything that, well, if it's proven that this person has interfered in the process in spite of this express reservation that they shouldn't. So I just wanted to understand, well, I like the provision. It's an interesting provision, but I was just taking it to the next natural conclusion, and I don't get it. So I think it's good that it's in there, but I think it's still missing something. So I had one other issue, Madam President, in terms of how we move forward, and it had to do with the issues inside of the schedule. I listened earlier to many of the contributions, Madam President. Madam President, we need to get to a place where there's rigor in what we do. We are very used to, in Trinidad and Tobago, working with loose systems and things that are not rigorous. And when you look at the schedule, you are placing, actually, it's forcing, putting pressure on persons to be truthful. So let's say that you have a property and you have 3 or 4 tenants renting. You actually have to provide what your estimate of the rental you're going to receive, but you also have to put the names. And I think it's important that you put the names, because if you don't do that, then you are essentially saying, well, we trust you, Mr. Landlord, to provide absolutely truthful evidence to the state. I would like to say that if I were the Minister of Finance, that is not a step I would want to do, because landlords and a lot of other types of business people have proven themselves to be not the person in them who would want to repose all this high level of trust, particularly when you talk about getting revenue to the state. So that I like inside of the schedule where you make people put as much information as possible so that they can justify. Because what it does, it forces them that if they know, this is where the issue about willfully putting wrong information in the form comes in. Because I listened to the argument about the 500 and the 500,000, but for me, I grab the point that, the same point that was raised earlier by Honorable Minister Lee Hunt. It says willfully. It's not that, well, I made a mistake. Okay, I am not an attorney, so who's going to determine willfully does it? The attorneys on the bench or other places could explain that. But for me, it doesn't just say, well, you made a mistake on the form and you will be fined $500 or $5,000 or whatever it is. It says willfully does it. So that means that, for me, that means some type of objective test needs to be passed to demonstrate that you willfully put the wrong information. And if you willfully try to falsify information that will diminish your taxes payable to the state of Trinidad and Tobago, you should be hit with that fine. There's no, I can't see any real reason for anyone to object to that, but of course, this is a democracy, Madam President. We're all entitled to our own views, and I just have 1 or 2 views on these small matters before I close off. So that, small matters. No pun intended, Madam President. So, Madam President, I think that what we are trying to do here, Madam President, is put a filter, put some rigor around how we develop the valuation system in Trinidad and Tobago that is going to feed into the Property Tax Act. where we are as a country, we're trying to improve our systems as we go along. I see this as one step along that journey. Because, and as in anything, Madam President, we're trying to do something different, something new. You're going to run into one or two little bumps. But I believe that you have to try to make these steps. We will always try to say, let's stop, let's consult, and let's get everything perfect. And then what happens many times is that you don't move. So that I believe that we have to try to move. And I'm not saying it's right or perfect, but I believe that in the current form, with one or two amendments, I think we could fix it and put it in a place where we could get this done, and we could try to see how the citizens of Trinidad and Tobago, this is going to be important for citizens of Trinidad and Tobago to understand that we are here. We are all born here. We have the ability and the right to enjoy life in Trinidad and Tobago, but life in Trinidad and Tobago is not free. And that we should all be able to pay our taxes, and that if you have a property, valuing your property should be done in a way in which it allows the state to be able to charge you the taxes in a fair manner. And I don't see any huge devils or anything inside of here. As with anything, Madam President, there will always be outliers in every system. There will always be probably a few people will always have challenges, but I think for the vast majority of people, this is not something that's going to unduly, disrupt their lifestyles or cause any mass hysteria. I don't get that, Madam President. And as I begin to close, Madam President, I come here every day, or as it is every day, I think I'm going to be here in less than 9 hours. I'm going to be back in another room here doing another duty. I think I'm a part-time person here, Madam President. So someone said in the SRC report. But I believe that when we come here, Madam President, I come here with a focus on getting things done for Trinidad and Tobago. That's what I come here, that's my focus. And that when I come here, I try to look at the whole picture. So I understand everyone has concerns, I have concerns as well. But I try to roll those concerns up to try to understand in the global activity that we're trying to do here, we're trying to improve Trinidad and Tobago. And if in part of that involves improving the revenue capture system for the state, putting some shape and some rigor around how we do that, that is something I could support. So, Madam President, with those few words, I wish to thank you for the opportunity to join in this debate.
Minister of Finance.
Thank you, Madam President. Madam President, before I start my response on the matter that's substantively before us, I would just like to correct the record in respect of a comment made by Senator Ameen in her contribution. As was done by the other side after the first ruling in the Devon Barrage against the valuation of the Valuation Commissioner matter, when the UNC claimed victory in that matter, again they sought to claim victory today in the matter involving the Eden Gardens. So I would just like to correct for the record what happened in that matter today. The judge in that matter originally extended the period given to the state to file the documents beyond 4 months. Today, she overruled that order and said she ought not to have given that extension. So what is now required is the matter needs to be refiled and the substantive matter debated. So it is not that the other side won after the substantive matter was debated and a decision made. It is merely the form that needs to be corrected. It will be corrected. The state is determined to pursue and prosecute these matters, and this is where we are, just for the purpose of correcting the record.
Madam President, I beg to move that the Senate do now adjourn to Friday, April 20th, 2018 at 1:30 p.m.
Honourable Senators, the question is that this Senate do now adjourn to Friday, the 20th of April, 2018 at 1:30 p.m. All in favour say aye. Aye. Those against say no. The ayes have it. This Senate now stands adjourned to Friday, the 20th of April at 1:30 p.m.